Just by back to mention item number 42 of today's list document.
42 of
Today's list document. Last item of admin.
yes. What is your prayer?
That's our affidavit.
Uh-huh.
I may be allowed 2 weeks time to file my affidavit. I have
Yes,
already
ma'am.
taken the consent of the other side.
But it was mentioned, I think.
It's a fixed matter of
Item
is.
42.
item 42,
You have taken consent.
consent of the other side.
You are on behalf of
Animal husbandry and veterinary department.
understanding council press for and is granted. How much?
2 weeks time.
2 weeks time to file.
Oh, let's
You know, stop.
I put item number 44 and on behalf of Mr. Matter may be
Okay, on whose behalf?
You.
For respondent number for petitioner.
petitioner in item 44, 45 respondent.
And have you taken consent from the
That
give the file, give the file. You, this will be called orders method. Wait for something. Wait for something. Yes.
mention item number 10. What is this?
Mm.
Item may be taken up for
When this good occasion will come to take up this matter in motion? When the auspicious time will come? Mm.
Then my it
Mm.
some
What vital instruction? This matter is in motion for almost since when? Certain things you cannot keep in ventilation. This is not appreciated. This matter is for months. How many days I do not know. The orders which are bigger than the petition. Only adjournment. Wait for something.
In item number 52, because we are filing additional affidavit. I mean, we allowed to file
Additional affidavit.
Yeah, please. Item number 29.
Mr. Not. So let us wait for the affidavit to come.
I have taken extra copy. I can give it or let it come.
Let it come.
Look.
We have three sources. Item number 20. I'm on behalf of T.R. Gogol.
Item number?
29.
Yes.
Respondent number 2 and 3 are going to file affidavit. So I pray for 1 week.
You are for whom?
T.R. Gogol.
No, do you understand? For respondent, housing board.
Yes. 2 and 3.
Have you taken consent?
Yes.
I'm free.
Okay. The learned standing council for housing board, prays for and is granted. When?
1 week.
1 week time to file affidavit operation. Please record it.
Okay. Research. Madam, maybe passport time be.
Why?
The file is written at one of my I will collect. On page number 12.
According to no review, DPC constituted. When have you saw a copy?
Page number 40
Yes.
is the representative.
How do you know that it was received by them?
Signed in
Hmm?
petitioner informed. Signed.
Where is your statement that you have this was duly served? Madam, you are in a contempt proceeding. Hard MS. I'm the Planet Council for the petition. It's an application. It's an against the consultant. A specific statement at paragraph 5 of the petition has been made that the representation filed by the petitioner on 26/9/2022 has duly been received and an acknowledgement being acknowledgement with a reference number 948 was given. Considering the above, issue notice 6 weeks both ways.
Keep public.
It's the contempt for complaints of the order dated 31.
Where is that?
Page number 26. The common order. The relevant portion is page number 49. And for application number 48.
49.
49 yes.
49.
49 yes.
Where is your notice?
This page number 58. I have submitted the
50.
58 5. For 13 to the 48.
Notice 6 weeks both ways steps.
Omelette. Pilot matter may be taken up to
Why?
by the end of
Huh?
the birthday.
Time being. None appears for the petition to resolve. List of topics.
Lordship, the relevant portion is at page number 14. There are correct. Yesterday they filed one IA in extension of time or
They have appeared or what?
no, they have just served me a copy. I don't think that they have listed bring us also going to comply.
So what to do? Wait or issue a notice? Notice. 6 weeks.
I will
Yes.
Even page 14, paragraph 9. Okay.
Where is your notice?
Page
Hmm?
15.
Where is your statement that it was duly received?
10, Lord.
Paragraph?
Yeah.
You still not. You must have a statement that you can track it.
Yeah, Lord. Paragraph 11, Lord. He already, Lord, communicated. Okay. Okay. Okay.
This is not a way. This is a contempt jurisdiction. We can send a person to jail. So we must have a satisfaction that you have duly served. He has not complied with.
Yeah. Yeah. Motive. Motive. Receipt
We
of-
do not want to unnecessarily bring a person in a contempt.
Page 50, receipt of-
Huh?
The receipt of-
Receipt is there, but we do not know. You can track it. File an additional affidavit tracking it.
Not, I have started the number,
Hmm.
but after 3 months or 141 is
Now, who will consider state level committee?
30 the one number is the secretary is to place the paragraph 8 page in secretary comment order mitigation method is the proposal of the method
Who is the standing council irrigation?
by the
Is he here? Wait for some time.
owner.
May please your lordship. My lord, order, my lord, page 12,
Yes.
page 12. Operating cost page 15, my thereafter.
Where is your
My lord, para 16 is the my lord represent, which was duly received, my lord.
by whom?
By the my lord commissioner, and then para 18 is the my lord,
Para?
para 16, commissioner, my lord. Then para 18 is the my lord executive officer, duly received.
Then, my lord, some communication are
From?
made between the my lord commissioner and the executive officer.
Now, what is the direction?
Direction, my lord, the direction, my lord,
Who are the respondents here?
respondent, my lord, commissioner, Panchayat.
Why commissioner? How commissioner has committed contempt?
My lord, commissioner was directed to my lord last sentence.
Hmm.
It is submitted at the commissioner of the Panchayat and Rural Development Assam may act upon it as per the law and to the need. My lord, and earlier part, perhaps, my lord, the executive officer complained.
So until and unless executive officer sends it.
My lord, already sent me page 21.
Hmm?
Page 21, my lord.
Page
21 to 1.
This is from Chief Executive.
Chief Executive Officer to Commissioner, my lord. Authenticated report of the document of the petitioner, my lord, verified and
Then how he has done contempt?
my lord, but the part, my lord, is yet to comply because, my lord, the commissioner of the Panchayat, my lord,
No, we understand, but how executive officer has committed contempt?
executive officer perhaps complied.
To comply, so we need not issue notice to him.
Executive officer,
Okay.
only commissioner.
Third sentence, issue notice to respondent number 1 only. 6 weeks.
Highly obliged.
Yes, Mr. Chaudhary.
The petitioners before worship their grateful employee
Hmm.
in the director of health services. Now, their services were terminated, and that was under challenge. And your worship may come to the order
Hmm.
at page 13, relevant, my lord,
15.
relevant 15, paragraph 5.
Okay, now they have not done the in terms of the earlier judgment, 8716.
Yes, but the judgment your worship factor is page 14, paragraph 4. Further that.
Notice. Who are the respondents
Only
here?
one of the director of the
It's 6 weeks. Steps within 5 years. What ways?
page.
Yes.
So, the order is at page 12, page 14.
Page
14.
yes, who is to do is this.
But thereafter, at page 6, we have provided the order of possible.
Hmm.
There are some communication between the department. Look into annexure 6 at page 20. The department misguided themselves at the case
Page.
page 20. Look. Annexure. Sorry. At first, they misguided themselves that the case is still pending. It annexure 5, page 19. It was informed by the
This was the date when this date 8/11. This page 20 was issued on 8/11.
8/11.
Now, when have you
Thereafter-
served this copy?
Served this copy on 31st of July.
31st of July. Then,
Thereafter, Lordship, in spite of the order of the Honorable Court, they have passed an order at page
Hmm.
21, overtaking the order of the. They have also quoted the order of the Honorable Court, but they have not discussed anything about this order. So, Lordship, look into the operative portion of the at page 26, Lordship.
Hmm.
They have passed this order.
that is fine. This is, you have no objection.
So, we have objection. because-
31/3/2020, you have no objection. 31/3/2022, you have no objection.
30, your Lordship, look into the order at page 14, Lordship,
Hmm.
how the date of retirement was considered as 31st March 2023.
Huh.
But they have considered, by overtaking the order, Lordship, they have considered the date of birth of the petitioner as 1st of April 1952.
See,
Yes.
what is the order? Read at page 40.
14. Lordship.
Hmm.
In view of the above, without expressing any opinion on the core controversy regarding the correct date of birth of the petitioner, since the petitioner has accepted stand of the department and proceed on retirement with effect from 31st May 2023,
Hmm.
and in view of the fact that the department counsel has not raised any objection as regards the claim of the petitioner to receive pension and other retirement benefits as
Hmm.
per law, this decision stands disposed of by providing that the petitioner's claim and retirement dues be settled as a.
Huh. So they have, in terms of the 31/3, they have determined.
But they have not determined in terms of 31 period. They have determined in terms of their
In they determine, how do they determine that you will retire on 31/3/2023?
so these all they have filed a petition regarding our discrepancies in for the date of birth. Also.
Huh.
They said in the writ petition also the department counsel, both the counsel for the accountant general and for the department, they have considered after considering the submission of both the parties, also my date of birth was considered as 31/3/2023. Now, in
How
this
can be your date of birth 31/3? Your date of retirement should be 31.
retirement,
Yes.
retirement, yes.
So accordingly, they have determined that you have already been retired on 31/3/2022. That determination is to be made on the basis of date of birth.
But also, we have since there were discrepancies in my service book and my different records. That is why I approached the honorable
So,
court.
but in this court has not endeavored to decide whether your date of birth is correct. Date of
If you Lordship may look into the paragraph before the on the same page, Lordship, Mr. Cole, learned counsel for the petitioner further submits that with effect from 1/4/2023, his client has
this order, you need to challenge once again. So far, relating to the pension, court says since you have accepted your retirement on 31/3/2023, without going into the controversy, ask them to pay you the pension.
Yes.
Is it your case that you have not been paid pension?
Yes.
So that we can examine, but can you say that this is a wrong order because your date of birth is taken differently? Can we determine in this contempt?
No, that I Lordship today, if they are not complying with the order that
And there is a recovery.
regarding the pensionary part only, the Lordship.
Huh,
may not be no issue.
that only. So that is not your case should be, this was the direction,
Yes.
but you have argued that they have set over the order of this court and passed this order.
Yes.
If that you want to say, then we will not issue a notice in the contempt. You will have to
I
challenge
would
this.
receive my pensionary claim.
That should be your issue.
Yes.
Nothing more.
Yes.
And there is a recovery. Which one is your department?
Respondent number 4. 4 is the principal accountant general, Lord. And
Sir, you are also who is you are who is no, not the accountant general, is he? So according to you, that your department has already forwarded the pension papers.
Pension
Where is
papers,
your
they have-
statement? AG will come later. First, your department will have to forward the pension papers. Where is your statement? That your pension, who are the respondents?
Respondent Lordship, Principal Chief Conservator of Forest Lordship. One is the additional Chief Secretary to the Government of Assam.
Hmm.
Two is Under Secretary to the Government of Assam.
Show us who has not done your statement. Where is your statement that your grievance is not pension, not payment of pension?
This order,
No, this is not your case. Your case is that you have challenged that order in this content. All statements are like that only.
that we-
See,
Your Lordship, look into the my paragraph 7.
paragraph 7, yes.
It was incumbent on the part of the respondent to comply with the order of his Honorable Court dated 28/7/23 within 31/10/2023.
We understand that is a general statement that they are deserving. How? How? By not paying pension. If we go further, your case is that they have set over the judgment of the High Court and passed this order. This is your case.
Lordship, I have not received my pension.
Where is your statement? We are in a contempt jurisdiction.
Lordship, they have not complied with the order.
We will not hesitate to send a person to jail. At the same time, we'll strictly follow where contempt is done or not.
Your Lordship, look
Yes.
into Annexure 5 at page 19, Lordship. Page 19.
Huh.
Lordship, they have misguided their fact that the case
That is your case. They have misdirected and determined something different. This is not a contempt.
And Lordship,
If you want your
Lordship, look in-
assistance,
if your Lordship
if
look
you
into the-
want your senior to come, he may come, or otherwise with this structure, we'll dismiss this contempt.
Lordship, I take it other day, Lordship. My
Okay.
name is not
Okay.
real today.
Okay. On the prayer of the learned counsel for the present, let us sensation will be. Yes. Give a date. Friday.
The grievance of the petitioner,
Hmm.
page 9, para 12.
Page 9.
Para 12.
This is your ground.
The grievance.
Who are the candidates?
Uh-huh.
Who are the candidates who have not appeared and selected? They have not added them also.
Lordship, on earlier occasion, Lordship, during the motion, it has been asked by the Lordship provide the details of the some candidates and mentioned. So the petitioner did not provide that.
Which?
There's some candidates who have not appeared in the examination, but they were selected.
We are
The details
dismissing.
of the
We are dismissing this. We are dismissing this.
that time paying for the time.
You have been taking time in the motion stage from 19/4/2023. Give way to others. Dismiss.
Abhay.
appears for the petitioner for list of the
My lord, the case of the petitioner is that, my lord.
Hmm.
For the words of the criminal proceeding, my lord, I was not.
Yes, yes. Who is the epidicial? Name soon. Name soon.
Yes, name has
Wait for something.
at 2 o'clock, my lord.
Inform them. We'll take it up.
If he comes earlier, my lord,
We'll see, but we'll see.
Wait, with you.
Yes, where is health and all?
Petitioners are
Now, what is the present status?
now after direction of non to court, they have appeared before the committee.
Uh,
And they have
so,
still not taken any decision.
You
Now
tell
the
me,
first year,
you
first-
tell me, initially you were under that quota.
yes, we are
Now, why initially it was your admission was cancelled on which ground?
they have cancelled on the basis of the direction of non to court, wherein they have asked, there was asked verify. They have made a verification and found that we are not. All has been cancelled. Many among us. So we came before this.
No, we understand.
Then-
Yes, yes, where is health?
Then we came before this honorable court. The court directed us to appear before the select committee. And then, in the meanwhile, a division bench judgment was also. Division bench judgment has said that the honorable direct single judgment, so interfering and then direct. Here, what has happened already? The direction was there to appear before the committee. We have appeared on.
Now, what is
on
the
that date-
what is the purport of division bench judgment?
The division bench judgment, your lord will find at page start from 47. Division bench judgment took a view. Sorry, the page it starts from page 47, and the operative part, your lordship will find. It's a long judgment, your lordship. Holding Madhuri Patil has been taken into consideration by the, and at
It
last
starts at page
it starts from page 47.
47.
47. But basically the direction
Hmm.
was at page 58 only.
So, what I could understand is that beyond Madhuri Patil, there cannot be any roving and fishing inquiry. Isn't it?
Yes.
The matter ends there.
So now, my lord, he has already appeared
Ah.
before the state level scrutiny.
Decided.
before the
They have
second-
not taken us.
That,
So we have to.
that instruction, my lord,
You will have it. We'll have it
Well,
tomorrow.
that If they take it up, your lord.
Well, tomorrow.
but my lord, the concerned council is not present. I suppose.
Who is concerned counsel? It's a medical admission. You know, Mr. Gogoi.
So, my lord, that
We
period is
understand.
over.
Over.
Now he cannot be. No one can be admitted now. At best, my lord, if he is found, my lord, genuine, then it can be considered in the next for the next session. That is in 24, not this.
Why this? Why was his candidature was cancelled?
My lord, what happened is, my lord, there was a direction of this honorable court
No. How this the direction was passed?
passed by page
Single
40.
Huh?
Yes, my lord,
There was a
page
direction of
44.
the single
How
judge.
it was? How who filed this writ petition?
It was filed by some
Another person.
another person, but honorable court directed that entire person who candidates who have been selected for this under this category, all will have to be examined. Then it was found that, my lord, they are not. Otherwise, my lord, the committee observed that, my lord, they are not.
Not committee. Not committee.
No. It is a state level committee only. But, my lord, they finally said that he is not a genuine candidate or he is not entitled for this particular
But
category.
state level committee finding is not on based on the.
No, I'm
Yeah.
not on that. That part division bench has already, my lord, made the observation.
So if division bench is made up, suppose we decide that I think that he is rightly been selected.
Then this session it is not permissible. Even the Honorable Supreme Court has said, my lord, 30th September is the last date. Thereafter, my lord, if at all something comes up because of the fault of the authorities,
Now let
it can be
who,
extended.
what was the last date of admission?
30th September is the last date.
Ah.
Pursuant to a, my lord, new judgment of the Honorable Court reported.
No,
in-
that we know.
Yes. That is
So
already there. It
Hmm.
can be extended till 30th of October, say another 30 days. But only 2 seats can be created if required
Hmm.
by the Honorable High Court. So accordingly, 2 seats were, my lord, directed. 2 seats were, my lord, already filled up. Thereafter, there was a direction to create 2 seats.
Hmm.
So 4 persons were inducted by the division bench.
Hmm.
And only their part, Honorable Court has interfered, stating that, my lord, what their names, which the names of those appellants which appear in the report of the state level committee, that has been set aside. Only that part, Lordship may
No,
kindly see that
is
part.
delay is for whom? For courts and for the SLC?
Here
Is
in
not
the
it?
case of the present petitioner, till today the report has not been submitted.
So it's whose fault? Either on our fault or on the fault of the
In
SLC?
fact, the court has specified a date on which date I have to appear. On that day, I have appeared.
Who is representing the?
That was on 16th of
RM
Your
does.
Honor.
Yes. Yes.
State level. RM does.
We'll get a direct personal appearance of the director. Where is RM Das? Okay, we'll wait for some time. Oh, forget about that. Are you aware now? Oh, you be here. These are sensitive issues. Don't be technical. A student is awaiting for admission. He was duly selected. Somebody has come to this court challenging. Then it was
General or
a general order was passed. Then division bench. Whose fault for this student? Who will compensate them? Don't take these technicalities. Rise on the occasion. Yes. Next. Call Mr. RM Das.
Contempt.
Mm.
Lordship, kindly have a look at page 12.
Mm.
Was provided by the learned.
No, 13/10/2023 order, last order.
Last order, Lordship, particularly
File and affidavit. Mm. The learned, Mr. L.R. Mojumdar, learned counsel for the petitioner, submits that pursuant to the order of this court dated 13/10/2023, a copy has duly been served upon the present incumbent. Full stop. Accordingly, he prays for and is granted 3 days time on after vacation. 5 days time to file an affidavit incorporating file an affidavit file an affidavit. Full stop. List accordingly. First week, give a date. List immediately after you open.
of like
List in the first week of January. What is this?
Page 14 is the order.
Page 14. Okay. Yes, sir.
Okay, I will take the instruction.
You have the instruction. Full stop. The basic grievance of the petitioner is that, in spite of the order dated 36/2023 passed in WPC 3865/2023, the commissioner and secretary to the irrigation department has not sent his name for consideration to the state level committee. Isn't it? State level committee. So, this court has requested Mr. Bajaj, who has readily accepted to obtain instruction regarding status of the complaint.
Only the secretary from not committee.
A secretary. He will have instruction from
Lordship, I will have.
secretary. Huh? Accordingly, list Friday.
Lord.
List it on 22nd. In the meantime, a copy of the petition be given to Mr. Bajaj and his name be shown. Name of the pencil be shown in the cost. It's reflected in the cost.
All right.
These methods you have sent, or you say that we are sending.
Probably, Lordship, it is already placed before that.
Yes.
Altair was called for Lordship. Altair didn't.
Not received.
Not received.
Only received. Not received. Fake currency.
164 days. 10,000.
The problem is that now after third sheet is filed, only on the ground of detention you cannot grant. Okay, case diary call for not case diary. Scan copy call for has not been received. Registry to issue reminder. forthwith, issue reminder forthwith, and list the matter, even if necessary, by special messenger. Full stop. List this matter on 22nd. Not received. As and not received, as this matter involves right of right of life and liberty of the person. Registry. 22nd. We'll see on that. What is the amount?
10,000 rupees on Monday for 2% is there.
Lordship, in this case, Lordship earlier rejected by Lordship that further that a last date of order is Lordship on 16/10.
Hmm.
So it was rejected on 19/10. Up to date is there. Everything was as it is. So up to date will be required.
Up to date case there.
Lot-
Case there is not up to date.
Case there is still 16 and order was rejected
not
on 19.
19.
So nothing.
Still there is a share of apprehension. If your lordship may just grant that.
Very bad.
Difficult.
No, however, there are many issues your lordship. I will set.
Okay. What are new grounds? Give us
Here,
a-
your lordship, which was not taken up as in plea in the first petition. The first is the jewelry which was been seized by the investigation.
Hmm.
Are actually the belongings of the mother of the petitioner number 1, for which the necessary Jima petition has already been filed, and that
Jewelry belongs to whom?
the mother of the petitioner 1. Yes. The second is, your lordship, there is something impossible to believe that a person
Hmm.
who has went to collect the money,
Hmm.
can she wear a lot of jewelry at the time? This is the second aspect. The third aspect, your lordship, generally what normally we see is the Manipuri woman, they doesn't wear other kinds of jewelry except the Manipuri jewelry. So that again has already been inducted here in this matter. That is the another aspect. Secondly, your lordship, the car which was seized during the course of the investigation was lying in the garage for 4-5 months, and which was projected here as an weapon. So that, if required, we will be able to provide our CCTV footage. The car which was lying in 4-5 months for the garage in the petitioner's number 2. Then, your lordship, the car which was seized by the investigation officer during the seizure, at the time of seizure, there was no any stain in that car, which was later on been put up by the investigation officer in front of the other accused. Then thirdly, your lordship, when this the petitioners was been arrested, the investigation officer himself disclosed that the PM report discloses that it is an accidental death. Then if it is an accidental death, 304A will come here, not the 302. That is another act. And moreover, if your lordship will see another thing, the accident took place in between 9 to 10 p.m. as per the media report. And on that day, both the petitioner was involved in the marketing at the daily bazaar at approx 6 p.m. in the evening. And the daily bazaar is 215 kilometers away from the death spot. Then ultimately, we will have the benefit of free of alibi here in this matter.
In bail?
That is the decision of your lordship.
No, it's not discretion. Our discretion is to be exercised judiciously.
Yes, yes.
We are not monarchs that will exercise our discretion as we wish. Discretion
This
should
one
be
our
based
duty
on
is also to assist the
sound judicial principle.
All the accused person have admitted how they have killed.
admitting something before the police official is not at all admissible.
Not admissible, but still Lordship. Now as the case is not, trial is not.
The investigation has generally progressed if you're not with the. Moreover, they were also been granted an interim bail by the district and session court.
To whom?
To this petition.
Granted bail.
Interim bail. Later on, that was rejected.
So why it was rejected later?
Your lordship may just see
Tell us.
at page 36, starting from 34.
Just read it.
Annexure 4. At page 37, it goes with, after hearing both sides and perusal of the forward report and seeing the objection of the IO, I am view that in forwarding report investigation officer simply mention that the accused persons are merely on the call details record prior to the occurrence of the incident. However, the forwarding report did not contain any details as to how both the accused person involved in the alleged occurrence of the incident, and it is merely on assumptions. Under the aforesaid facts and circumstances, both the accused so and so shall be released on the interim bail furnishing a bond of 50,000 each.
Again, rejection.
And after that, on pursual of the at page 39. On pursual of the CD, it appears that the accused person, namely so and so, are not cooperating with the investigation of the case as per the order of the court. Pursual of the CD further reveals that the investigation of the case is going on. In view of the above, the interim bail so and so is hereby vacated. At page 13. Therefore, you lot generally the investigation has moreover progress. At least the interim shall be granted so that they can cooperate with the
We have already
investigation.
heard it. Will now reject it. Reject it.
At least you're not doing it.
This is not absolutely a case. We'll give our good reasons this time.
Oblige.
Keep the CD.
Then you lot may just another point I think lot may just add that they may be at liberty to approach the concerned court for a record.
No, regular bail question is not coming at this stage. Moment you are arrested, then only regular bail. Where is the question of regular bail?
So they should be at least that liberty to approach the concerned.
You are
In
always
case
at
they are
liberty.
arrested.
What kind of liberty is this? Article. Yes, sir. I think that relief has been granted. Isn't it?
That instruction also.
Ah.
Lordship had a- But petitioner was asked to append the instruction
Ah.
with regard to that. Because this is relating to payment of their wage.
None appears for a petitioner on call. Mr. B. Goswami, Learned Counsel, appearing for respondent number 1, 2, and 3, submits that the order he has been instructed by his client that the order dated passed in WPC 6213/2023 2013 has already been complied with. A copy of the communication addressed to him by his client is also forwarded to this court, which is kept on record and marked as document X. In view of that, the contempt petition stands closed. No, no. Just a minute. No? Not aware of you. of Madras Panchayat Judge and listed after.
But-
This is education. What is this post of lecturer?
Post of lecturer in
Department of English. In which college? Okay, adjourn it. I have some doubt whether I can take up this. That's why. Anyway, no. Not late. Not yet. The orders. In the month of no date. Yes.
Item
This
number
is item number?
47.
Huh?
40, in item number 47, the Honorable Lodgement could directed to take precedent.
Hmm.
We have taken a step
When?
1312.
1312. Where is the order of lodgement? Nothing like that. Which order of lodgement code?
Item number 27.
Item number 47.
47.
Okay. Is submitted by the learned counsel for the petitioner that pursuant to order dated 11/12/2023. Not. You need to sensitize your officers. We have now a new trend is there. Suppose a contempt notice is issued. He is no more holding the post. It is by name.
Right.
He will refuse. More particularly this man, Manish Thakur. We have issued a bailable warrant on last occasion against this man and asked Dispur police station to execute the warrant. In every cases, if he is not there, he will refuse. Is it permissible?
No.
Can he decide that I have not done any contempt?
No, at least he should accept the notice and
You engage or at least you write a notice, and even then, if he has during his period he has not done his part, even if it is complied, we may take that it is a contempt.
Yes. during his tenure.
His tenure, what was his role? Let him say what he has done it.
Yes.
See, this is the second case I have got.
I'll
We'll take it up this matter next week.
I'll-
More particularly this man.
Yes.
This is not done. List next week
warrant.
showing name of Mr. Nath Lanet. Just to assist us.
Yes, the warrant has been issued in this case.
No, not in other cases. So they were.
Can I put the number of
Not next week. This week, Friday.
Right.
Friday. Can you give that order to?
I'll
Okay, Usman. Give that order.
I'll pick.
That's kindly pay to order dated 20 dash.
Yes, Thor. Where is Thor? PWD standing counsel. Now, not. Now the second example. Executive engineer has sent a parawise comment to us.
To court.
To court.
So that I have already written a letter to the the Chief Executive Law that he should instruct all the officers not to address any letter to the honorable. I have already written, my lord, possibly they are in the
Now,
process of
court, for that parawise affidavit means he has been represented. So passes an order saying that accordingly respondent shall file affidavit in opposition. Who will file affidavit in opposition?
nobody has entered it.
Uh,
I have already taken up that notification for
Okay.
which is coming.
The executive office note dated 8/11/2023 reflects that the executive engineer PWRD, Lakhimpur, Ranganodi and Bihpuria Territorial Road Division has sent a parawise comment in the contempt petition addressed to the registrar within bracket contempt. Full stop. In view of that position, Mr. D. Nath, Learned Standing Counsel, submits that he may be granted some time to obtain instruction under what circumstances such kind of such communication was issued by the executive. You just take note of this.
Yes.
This is what we are facing every day. Wait for some time. Let him in the first week of January. You just have give some instruction. Contempt is not like that. We are
Correct.
strict in issuing even notice.
Correct.
But if it is done, it's difficult. Next. Yes.
Last occasion, there was no evidence found in evidence. But there was a direction. It appeared for
None has appeared. There is official.
it may be expired.
Okay. This matter is ready as regards service. Accordingly, fix this matter, list this matter in the admission column after in the second week of January. In the meantime, the parties may exchange here.
We have filed our
And if you
None appears for the petitioner on call.
I am waiting for the official respondent.
The further appears for respondent numbers.
Official irrigation.
Irrigation department. That is
Okay.
respondent numbers 1 to 5.
1 to 5.
1 to 5. Lajima Court, under its order dated 13/12/2023, directed the respondents, a petitioner, to take steps for service of notice upon respondent number 7 to 12 by registered post as well as AD. Registered post with AD as well as usual process through the office of the Learned Civil Judge within bracket Junior Division Kamrup Metro in respect of within bracket in Resailaba office note 2020. Though a mention has been made for urgent listing, however, none appears for the petitioner on call and no steps as directed by the Lajima Court dated 13/12/2023 has been taken in that view of the matter. However, in the interest of justice, matter stands adjourned and be listed after 6 weeks.
The review petition that the lordship asked me to take it to a judgment part. That there are two parts in that judgment. One part is that they did not put forward those grounds. So ours is that put covered. But then the other part lordship is saying case
Not maintainable.
not maintainable. So since lordship has passed a year, it will look as biased if I submit because Lily Thomas is there, lordship, there are certain mistakes. Court has the power, but still lordship will look like a bias if it allows my petition and it. So the first part, lordship, I'll say that that won't be applicable. That we do not press for the ground because income that ground was at lordship has discussed that, and that the professional tax and he was not. But the lordship says that
Okay,
not
we'll
better,
pass an order. We'll
yes.
see.
If it is early lordship, then it will be better.
Early,
So,
early, because at the earliest so that you can.
because we will be going,
Well, which judgment you are relying on? Lily Thomas.
yes, sir.
Citation?
Citation lordship, 2006 SCC, 2000,
2000, volume 6, SCC.
224. Lily Thomas, etc. versus Lily Thomas.
Okay, we'll pass this order.
Hello, okay.
So we filed this IA for when in the like when orders have been passed.
Uh-huh.
We have filed this IA for correction in the cost factor.
Correction in the cost title. What is wrong?
The respondent number 3, the representative of respondent number 3 has been wrongly mentioned as Deputy Commissioner Kamrup instead of Deputy Commissioner
It should be
Lakshmi.
It is in Lakhimpur.
Your Lordship, in the order dated 15/2023 and 26/4/2023, it's been reflected as DLC.
Where is your original petition? Cost title in defect in cost title in 739 or in order?
In the orders, in the petition as well. Your
We have not served the copy.
Who committed the mistake? You committed the mistake in your cost title.
Yes.
Where is the cost title? Read, please. So you have written as
the Deputy Commissioner
respondent number 3, Kamrup. So it's a copy paste mistake. Yes, hard MS. That's Learned Counsel for the present application is filed for correction of cost title. That is the it is the case of the petitioner that the respondent number 3 in the connector read petition, which is the district level committee, is stated to be represented by Deputy Commissioner Kamrup, Guwahati 781001 by mistake, and it should have been Deputy Commissioner, not Lakhimpur. Sure? Deputy Commissioner, not Lakhimpur, pin
78100.
How can that be? Again, see your correction. See your IS. Look at your IS. District level committee represented by Deputy Commissioner Lakhimpur, Guwahati 781001. We cannot. The learned counsel for the petitioner submits that she may be allowed to withdraw this IA and file a fresh petition. Your IA itself is defect, or I will have to say that you will have to first seek correction of the cost title of IA. Close. Motion cancel. Okay. Orders. How many respondents here? Notice has duly been served and respondent number 1 and 2 has entered appearance to learned council's first of accordingly. The respondents are given 3 weeks time to file affidavit. Yes.
As per my instruction, the matter has already been referred to the Directorate of Civil Rights and Civil Rights by the Social Justice Department for investigation. And as per my telephonic instructions, which I have received just now from the Director of Civil Rights, they have referred the matter to the CID for investigation. And now the matter is
Where is the CID rule? That has been already struck down by the writ appellate court.
no, that has not been struck down. Lordship. That is there. Lordship. As per Madhuri Patil, Lordship, as per Madhuri Patil judgment, Lordship, in Directorate of Civil Rights and then CID has to
Where
be
is that Madhuri Patil CID mandate? What is the division bench judgment says?
Division bench, your lordship says, I'm just reading that last. Resultantly, the impugn order dated passed by the learned single judge. That's where the whole matter was. The admission cancellation notice dated so and so issued for appellants are being quashed reversed. The report of the state level scrutiny committee dated so and so as per which the so and so certificate held by the appellants were declared as not verified, has also quashed for the appellants have already been provisionally admitted the first year course by virtue of interim order dated passed in repetition and repetition. Therefore, the interim orders are made. So that is with regard to those.
Others.
But this order was passed subsequent to the order passed in our. So we got. We were our order was.
Where is that writ petition?
Passed,
Where your admission is state? What happened to that writ petition?
that earlier my writ.
No. Your admission is stuck by virtue of a court's order.
Yes.
Where including you, others were also involved.
Everyone.
So there was a direction passed by a learned single judge. Then it went up to division bench. Division bench say nothing doing. All are set aside.
Yes.
So if all are set aside, where is the question of CID now?
No. Division bench has
This order, our order, somehow your lordship, what has happened? This order, our order was passed on 12/10. And the division bench judgment was passed on 19/10.
Whatsoever, as on date.
My lordship, may kindly turn to page 58 for a moment. The division bench order. Resultantly, the impugn order dated 19/9/23 passed by the learned single judge. So, and so the admission notice dated 28/9/23 issued qua appellant are hereby quashed / reversed. The report of the state level scrutiny committee dated 26/9/23 as per which the OBC, TGL, XTCL certificates held by the appellant were declared as not valid is also quashed qua the appellant. So only they have been protected.
No, we understand.
Now,
What was the principle of this division bench judgment? Now suppose division bench says that this is the Madhuri Patil's principle.
Yes.
You can go to this extent, not beyond this.
Right.
Now a petition is allowed. Writ appeal said that you cannot do, this is the principle, therefore set aside.
Right.
Now division bench is binding upon us, binding upon you.
Right.
Is not it? Now if Mr. Das still says that no, we have sent it for CID, is it sustainable?
No, it is as per my lord, Madhuri Patil's my lord judgment. That is the principle that is to be followed, my lord. Whatever it has been laid down there, there is a time frame also, my lord, at least 3 months will be required. So that part, my lord, they will have to, my lord, do.
Yes, when he appeared, in terms of the division bench judgment.
On 25, I think.
I appeared
as per this judgment. Single judgment.
Yeah. On 16/10. Because that date was given because 31 was the last.
16/10, 2023.
By January.
Now 16/11, 16/12, 16/1. So you will wait till 16/1.
No.
Because you have 3 months.
No.
Ignoring all that is a medical admission.
Not that, Lordship. We have to send as per Madhuri Patil judgment, Lordship. Social Justice Department has referred the matter.
Now we understand. For that you get a period of 3 months. Now you tell us what is the stage of this case.
Lordship, till-
See, this on 1610 he appeared. Then
No.
what happened? Tell us.
Lordship,
We want till that how you have proceeded.
Lordship, till date, Lordship, the matter is lying with the CID as of today, Lordship. Up to the, as per my up-to-date instructions, Lordship, the matter
You
is,
have a written instruction from your client.
Lordship, then I will have to.
You have a written instruction from your client where the matter is pending
Lord,
at this stage.
Lord.
Okay?
Lord.
We are taking it up on Wednesday.
Lord.
You are not being burdened. You can assist us.
Moreover,
Mr.
a copy of-
RM Das shall obtain instruction and apprise this court the stage of what we call it, investigation, stage of determination of the status of the
state level task scrutiny committee.
state level,
Task scrutiny committee.
status of the proceeding of the state level
Task scrutiny committee.
scrutiny committee on the next date fix. That is on 2012-2023. Full stop. 2023. Inasmuch as the petitioner had appeared before the said committee on 16/10/2023 as directed by this court, and till date, according to the petitioner, he has not been intimated about the outcome of such proceeding. Full stop. You have it. A copy of the order we furnished to you. Get it downloaded.
Lordship, I will. Lordship,
I'll
copy
give
of the
a-
petition,
I'll
Lordship,
give it.
because
I'll give it.
they have filed a case without filing a petition to us.
I'll give it.
Give it. To give today itself. Yes.
Now
madam.
only I'll.
Lord-
Data
Lord-
copy, photocopy it.
Okay.
Yes, Sharma.
Lordship, there was instruction was sought for with regarding. It has been placed that he will be considered for the promotion, next promotion, subject to his performance.
What of it, my lord, my salary, my lord, period of suspension, which, but
What is your prayer in this petition?
my lord, there is a twofold petition, my lord. One is promotion and another is, my lord,
Subsistence.
not only salary, my lord, subsistence and other part also, my lord, at para D, my lord. They have to regularize, my lord, because I have been reinstated.
Okay, we are issuing a notice pursuant to order dated 11/12/2023. Mr. S.P. Sharma, Learned Counsel for the APDCL, has on instruction submitted that the case of the petitioner shall be placed in the next DPC 4 within DPC's dash Roman 4 meeting. Which is going to be held within a period of 1 month. Full stop. This petition, by this petition, the petitioner has also raised his grievance regarding non-payment of his salaries and subsistence allowance, etc. Accordingly, issue a notice returnable after 4 weeks. Mr. Sharma accepts notice on behalf of all the respondents.
2 and 6.
Huh?
2 and 6.
2 and 6. Who are the others? 1.
One is state of Assam, my lord.
Why the state of Assam is required? Notice on behalf of respondent number
2, 2, 3, 4, 5, and 6.
2 to 6.
Follow. I go.
2 to 6.
2 to 6. And Mr. Bora accepts notice on behalf of respondent number 1. Okay. Notice made returnable 6 weeks.
4 weeks, my lord, can
4 weeks extra.
any date may be taken.
No, that let him have the instruction. Make a mention. Salary. Full stop. Pendency of this petition shall not be barred for the petition respondents to consider the claim of the petitioner so far same relates to the arrears of salary and subsisted salary. Even extra copy. You have invited, though he has no role.
Yes, I'll start without copy out.
Extra copy. Sir.
Yeah.
Name of some be reflected in the. It's next.
Instruction.
But if I suppose the wrongly listed the stay bracketing. But no, okay. There is another stay bracketing petition. Copy has been served.
There is a new stay vacancy. ISC 3609.
Yes, 36009. 5.
Huh?
5 or 9.
09.
0.
09, no order is passed. Why two stay vacating?
No, one stay vacating and one was for early hearing. The earlier one, the 3265.
Hmm.
The case is a very narrow campus. The petitioner was, the disciplinary proceeding was initiated against the
No,
petitioner.
yes, what you say, Mr.
Yes, stay vacating it is not in my file, but obviously it has been, I will serve extra copy.
Serve it.
Might have been thought point about the don't know, but not, it is not in my file.
Don't say that, Mr. Say that you need some time. We cannot look into who upon whom it has been served.
No, but in that regard, can it be taken up on my lord 5th of January, my lord? I will serve extra copy.
Okay.
5th of it was not hard to hang up. Okay.
I pass an order in IA. Issue notice returnable on 5th of, not 5th, give a date. 5th of January 2020. But can he file an objection if he wants by 5th? Again, he will seek an adjournment. We will have a
I
vacation.
don't think any objection is required on.
We know you have urgency, but this is a matter already admitted for hearing.
It is admitted, that's why we need
So can that be a ground for vacating a stay order? Yes, Arunachal. You are happy. You are happy. It's your officer, isn't it? So therefore you are happy. Stay, no problem. Yes. 5th will not be possible. Again, it will get adjourned. 18th. 18th. In the meantime,
only I will.
Okay. In the meantime, objection, if any, may be filed by the witnesses.
Apply.
Returnable on Heridia 18th return. Yes.
Pay for it.
We have decided before vacation. See, we time and again we said that before vacation may be difficult, but looking at the urgency expressed by the other side, we have picked this method today.
In several occasions, this has happened. Many times they have fixed the matter, and on the date when it is fixed, they have taken adjournment or some other grounds.
After coming.
What to do? If a senior counsel says that he is not well.
My prayer is very simple.
No, we know that. We have seen that. Because on last occasion we could not go through the petition. We have everything
the
seen.
last occasion has Lordship has seen that the Lordship was not even permitted to go into the have a bird's eye view. So that
no, we have our eye view.
Even then Lordship has seen the vacation of our pair because of the some fault on the part of the IOC, Oil India Limited. My money got stuck. Initially, there is a.
They have a case. We should take up the IA.
My lord, there is a direction from the court to pay into a particular account, my account. Then they have filed a case, my lord.
I've seen that.
And the money was deposited after depositing that his account.
Then they are after status.
Thereafter, there are status.
There are status.
So the IOC now in a dilemma whether to pay the money or
Of course,
the
because
oil.
they are having two orders. One is from the trial
Yes.
court and other is from the High Court.
So there is no clarificatory order to that effect.
So therefore, you have filed an IA.
Yes. So we have
It was
implemented
proceeded for compromise that failed.
Failed.
Now we'll have to either decide
the rest
on
of the
merit or on your IA.
on my IA that our limited prayer mail clarification that the IOC is not debarred to release the my order. That amount, my.
In fact, we had also filed an IA, basically seeking a clarification, and wherein an order was passed, we should hold the money, and we passed as of now. Till final orders are passed. So we had a custody of the money, and therefore on the court order.
See, this is a proceeding of dismissal 2015. I think court thought that way we will decide this. But if this is the situation, IA is not taken up, we will have to balance it. Whether we allow or not allow, that is a different issue.
Right.
But somebody has filed an IA. That is to be taken up.
2015 on from onwards, he is not
But
paying.
Mr. Bora, see, if a senior counsel comes and says that he is not keeping well, you advise her.
It's only the
No, so do you say that on that ground we should proceed? We understand. You
well,
client is-
then my if the lordship takes my advice, let it be parted and fix it on next Friday. That part.
when your senior can come? Tomorrow?
After vacation, second week.
Then again, this ploy will continue, my lord. This ploy will continue unless and until lordship takes up sternly, tightened in knob, my lord. This ploy is taken up by the several occasions.
Okay, we are giving a chance to the client, your client, to engage a different senior or argue.
Time we are
No, no, no,
taking
no.
a human it is
No,
taken.
no.
No,
absolutely
last
not.
occasion also.
No, no, last occasion also there is. See, my interim.
Now we'll have to record everything, and that is not possible. If we will have to record what is
He
been
could have appeared
argued,
by virtual also. Now that is available, my lord. When he can travel for the all day to the Delhi and other places, but he can't appear in a small matters when it is.
what
wife
happened
is-
to your, you have not challenged that order. That order you have not challenged.
Order we have pending.
That award,
No, no, that has gone, my lord, because there's a delay. So the Sessions Court has upheld the order. There's a delay of the several 2-3 years.
then High Court.
High
and
Court after the High Court is not admitting that because there are more than 3 years delay.
Okay, we'll take up the IA on Wednesday. We'll take up the IA of Mr. Bora's act.
This case,
No, nothing.
private
Your
attorney
dismissal
will
will
also-
look into. There is an order from a competent court. He has come, IOC has come. What to do, we'll clarify. That's all.
This
That's
fact has been dealt up with earlier lordship. They filed a stay vacating order lordship earlier also. This is the second time they have filed. And lordship, there is a clarificatory. The Oil India Limited has also.
So he
filed
knows
a-
everything.
Okay.
Let us
Okay,
start,
start,
my lord.
start.
Let's start,
It
my
will
lord.
not be
He knows everything, my lord. So you start it.
On
Because
Wednesday,
the
Lord, right.
wrong fact has
No,
been
no, no,
brought
no, no.
before
Let
the
him
court.
start, my lord.
That is why I have-
It seems that he is well
I am
aware of the
assisting-
facts.
Mr. Bora,
I am
no.
the assisting counsel. If the wrong fact is put before the
Yes,
court,
yes.
lordship, I am.
So you are.
Mr. Bora, please ask your senior. There is an urgency
Yes.
expressed by them. And this is a matter which relates to a dismissal,
Termination.
termination. Now, other parties, you're in the, by virtue of an order passed in a dismissal proceeding, a order of a court or a decree of a court is being stayed,
Yes.
and a right of third party is being violated. So they are definitely will insist.
And where we are misleading, my lord. He has said that we are misleading. That's why he is shouting, my lord. Where we are misleading, my lord.
Okay, so Wednesday.
Be
Wednesday.
cautious with your word, Mr. Counsel. Don't say we are misleading.
Wednesday, the learned counsel for the petitioner submits that the learned senior counsel leading this case is uh, is not well today. Accordingly, he prays for an adjournment. The learned senior counsel, Mr. A.M. Bora, on the other hand, submits that a validly passed order by a competent court is not being implemented by virtue of a stay order passed in this court, whereas the petitioner is the applicant in the IA is nowhere related to the issues involved in the present proceeding, that is the dismissal of service of the petitioner from service of IOCL Oil India Limited. Full stop. That being the position, while adjourning this matter till Wednesday, it is made clear that on the next day fixed, if the main matter could not be taken up or any adjournment is sought for, the IA shall be considered. IA filed by the shall be considered on that. Yes, Mr. Sharma, A. Sharma, learned counsel appearing for Oil India Limited has submitted that they could not implement the order of the trial court awarding maintenance amount for the reason that the order of status quo is operating, or order of status quo passed by this court is operating. Otherwise, they have they will abide by any orders passed by this
Public.
list accordingly. See, Mr. Counsel, you be prepared. These are the chances. You are good.
They find that issues of development might happen, and then wait for them.
Yes,
But
sir.
ultimately,
Well,
it will be contempt.
I have filed today an external application. But in fact, kindly take up that has come. Well, kindly take up the edition. Paragraph 3, we have stated. In fact, I'm reading paragraph 3. The department begs to offer his sincere and unconditional apology before the honorable court before putting forward
you
his
will deal with that apology, whether it is genuine or not. We'll deal with that after hearing your facts.
Yes,
Yes.
his explanation he has put on paragraph 4 on. Well, on 24/11/22, the honorable court in WPC number 2286/2021 has disposed of the writ petition by setting aside the impugned order dated 26/2/2021 passed by the state level scrutiny committee, by which the committee
That we know.
cancellation of
That we know.
that clause. The honorable court has relied on the inquiry report dated 3/10/2019 passed by the inspector of police CID Assam while passing the judgment dated 24/11/20. This is a vital thing. From that point, these things are.
Now, suppose we understand your case is that the basis was the report of a police officer. That report of his is fallacious. Therefore, whole exercise carried out by this court in the earlier writ petition, where the recommendation or something, some finding that he is SC or non-SC, that decision was bad. Okay. However, this court set aside that order.
Yeah.
Somebody went into appeal. Okay. That appeal was also dismissed. Your highest law officer has advised to prefer an SLP in that case, because state cannot prefer an appeal. In the meantime, somebody else has preferred an appeal. So therefore, that you are intending to file an SLP on the basis of the advice of the highest law. Okay. Now this court, in the backdrop that when the order of SLC has been set aside and the suspension order was based on that report, has also set aside the suspension. Okay. That order has remained unassailed as on date. Okay. And your case is that this is not willful violation, but according to you, the original judgment was not correct. Therefore, you are filing a review. Therefore, you will not comply with this order.
My respectful in between there are some
Hmm.
but kindly if Lordship takes up the additional affidavit.
Hmm.
But in the additional affidavit we have stated, but Lordship on 30/11/1912 I have stated, on 14 to 23 the personal department has sought views of the judicial department.
Hmm.
On 17 to 23 the honorable court has passed the order.
Hmm.
Then on 7/4/23 as per instruction of the honorable the chief minister, the principal secretary personnel department has directed to take a detailed opinion of the learned AG.
Hmm.
Then on 19/5/23
Tell me, is the opinion of the learned AG that don't comply with this
No.
order?
it is not. It is not.
Oh, then forget about it.
I have all the record. I have
Yes.
all the record.
Yes.
But on 14/6/2023,
Hmm.
the honorable chief minister Assam has also instructed
Hmm.
the personnel department to immediately file the writ appeal as advised by the. In fact, I have gone through the record. The writ appeal earlier filed, it was not in the record.
No, have you filed a writ appeal?
No, writ appeal was filed by some other person that they were the complainant. That came to the knowledge of the department lately. But then on 16/6/23, the as instructed by the honorable chief minister, the records of the file so and so were sent to the office. Then in fact, after the judicial department, the judicial view on 1/3/23, the judicial department has viewed that the legal remembrance judicial department has opined that the government respondent in WPC number 2286 of 2021 and WPC number 682 of 2023 has not challenged the orders of the orders in the writ petition, as there is no reflect of the same in the record. In the event of the order in WPC number 2286 of 2021 attained finality on being not challenged, the order in WPC number 682/2023 appears justified. The department to comply the orders of reinstatement in the reinstatement of Timothy Monson. That is the view of the judiciary. Then, my lord,
Where is that judicial view? Which paragraph?
serial number 6.
6.
Serial number. Then on after the judicial view, immediately on 9/3/23, the Secretary Personnel Department has moved the file for reinstatement of Monsoon Borkotoki ALRS before the competent authority, the Honorable Chief Minister Assam, for approval on the same, which is available at notice number 75 in the file. I have the record. Then thereafter, on 23/3/23, the Honorable Chief Minister has instructed to review the matter since finding of the CID and the state level scrutiny committee DC Jorhat are contradictory, and the LR has inter alia highlighted that the state respondents have not challenged the orders of the Honorable High Court. Thereafter, the Advocate General may be approached by the Personnel Department and Social Justice and Empowerment Department to offer his advice on filing of an appeal petition against the orders of the Honorable High Court, which may kindly be referred to note 79 and in the office. As per instructions of the then on 7/4/23, as per instructions of the Honorable Chief Minister Assam, the Principal Secretary Personnel Department has directed to take the detailed opinion of the learned AG. Then on 19/5/23, the learned AG Assam has opined that the judgment passed in WPC number so and so and all subsequent orders required to be challenged before the larger bench by filing a writ appeal, while explaining the issue of limitation by region. In fact, till that time, they were not the filing of the writ appeal was not within their knowledge. Then on 14/6, the Honorable Chief Minister Assam has instructed the Personnel Department to immediately file writ appeal as advised by the Advocate General Assam and request the Advocate General to represent the state government in the High Court, which may kindly be referred at note 93. Then thereafter, while preparing it on from record I am submitting, while preparing the affidavit, we came to know that already 1/6/2023 order has been passed, and therefore again the matter was taken up with the learned AG and then in that finally the AG on 3/12/23 he has opined that the state government or in between the person to the note the 23-3 to 2023 note of the Honorable Chief Minister, the Personnel Department has requested the Home Department to look into the matter of what has happened in the meantime. As regard the inquiry, what is the contact of the inquiry officer in that matter? Well, that inquiry report has been received by the Personnel Department. Well, in the review petition, I have an kindly for a moment, come to page 94. Page 94. The Personnel Department has in the meantime received this communication from the Home Department, and this Home Department communication has informed that with reference to the letter on the subject cited above, I am directed to inform you that, as stated by the Office of the Additional Director General of Police CID Assam, by their letter memo number so and so, dated 7/8/2023, there was no mala fide intent or conduct on the part of the Superintendent of Police CID Assam in connection with the inquiry. Necessary enclosures in this regard as furnished by the Office of the ADCP CID Assam is attached herewith for favor of your kind necessary action. Next is kindly see below.
Why are you showing us all this?
But-
What is the purpose? Tell us.
Well,
You are wasting judicial time.
The development in what has happened in the meantime.
On 1/3/2023, Judicial Department opine comply.
Lot.
On 9/3/2023, the Chief Minister of express opinion comply.
No.
Okay. Page 7. Page 34.
Page 34.
9/3.
On 9/3, it was placed before the filers moved. Filers moved, but on 23/3/2023, the Honorable Chief Minister has instructed to review the matter.
Okay, review. You file review. Have you filed review?
No,
Since March.
No, the department was directed to review that whether why the CID and the state level scrutiny committees report the views were ultimately contradictory, and to find out.
Let history may not forgive you, but let us uphold the dignity of this court.
My respectful submission is, Lord,
Let history do whatever history does to you.
because
We are drawing a contempt against him. He will file an application day after tomorrow, and then we'll decide.
kindly see page 95.
We are not happy with your explanation.
No, but
You may have hundreds of opinions. Until and unless the order is paid by a larger, higher court or is reviewed by the court, we are not going.
kindly for a moment, Lord, 95. Kindly see, Lord, page
Yes.
95. This communication.
In a lighter sense, I'm a fast reader. I have read from one to the last. Yes, read it. Because you should, your client should get a reasonable opportunity before he goes to the place where he is destined to.
Kindly see, Lord, this on 7/8/2023, the IGP CID, they have found that I would like to inform that the inquiry was conducted into the matter. The inquiry conducted by Sri Punamjit Nath, APS Deputy Inspector of so-and-so. The inquiry revealed that Inspector Depository Doctor, the then inspector made a perfunctory inquiry.
Yes.
The inquiry ultimately they found the basis of which the Honorable Court has passed the order. That inquiry has been found to be a perfunctory inquiry, and that report is also annexed. Report is also here. When report is at next page.
So, Mr. Nath, you want to say that in exercise of contempt jurisdiction, let this court have a prima facie view that the inquiry was perfunctory. Therefore, the original order set aside by this court was bad. Therefore, subsequent suspension order set aside should not be complied with. That findings will have to record.
No,
Can I?
No, my respectful submission that when the authority has found that the inquiry was a perfunctory inquiry, and which was the basis of the basis for the Honorable Court to pass the judgment, and in that, after having noticed that the authorities have decided to prepare a review petition in the writ appeal, and that review petition has been filed. The Honorable Court has issued notice in that, and the Honorable Court has fixed the review petition on 5/1/2024 for consideration. But that order is also there. Kindly see the order.
Okay, that is review in the other case.
But in the main judgment,
Hmm.
the where the inquiry report was considered by the honorable court, and ultimately the honorable court has held the inquiry report to be a correct report. But the authority has found subsequently that it was a perfunctory report with so many materials.
Okay, so
materials were not
we'll
considered.
say that we'll have to appeal the findings, subsequent findings of the department, ignoring the decision of a constitutional
no,
court.
no,
If
that
you
is-
suggest that,
No, that is not my submission. My submission is I am explaining why the department.
so therefore
ultimately
all
no-
these explanations are contempt, not only contempt, it's your conduct itself, it's a further contempt.
But
Forget about non-implementation of the suspension order. These statements are contempt itself in the affidavit.
but my respectful submission is since the department has filed they found that the inquiry report, which was the basis for the honorable court to pass the judgment, original judgment 24/11/22, and ultimately the legal remedy they have taken. Already the government has approached the honorable court by filing a review petition.
So was the principle of law that when government has sought a legal remedy, therefore everything should come to a halt.
No, my
If that answer is also no, then what is the purpose of filing this affidavit and non-complying with the order?
my submission is that
This is an absolute case of undermining the dignity of a constitutional court. Absolute.
The review petition is already.
You cannot play like this with a constitutional court. Not to say any other court. You cannot do this. No one is as big as cannot sit over the determination made. If there is any wrong committed by this court, that will be corrected by the appropriate forum.
In fact,
if this kind of judicial indiscipline are proposed and allowed, there will nothing, everything will fall.
The order in the writ petition, where the 17/2/2023 order has been. If for a moment can you take up that order?
You can take it up, but I am not getting your purpose. Suppose I am having a satisfaction that there may be prima facie satisfaction that there may be some error in the judgment passed by a coordinate bench. That's the first order. Second order is that so therefore subsequent order, suspension order ought not to have been passed. Therefore, there is no contempt. Is it a contempt jurisdiction? Therefore, they are at liberty not to implement an order because they have their satisfaction that the High Court passed this order on the basis of an erroneous understanding. Therefore, we have preferred a review or an appeal. Therefore, the subsequent suspension order, which is based on the earlier order, need not be implemented.
I am not saying that.
You are saying that only.
Understanding of the whole court as erroneous. I am submitting that.
No, that may be your case. There is no quarrel on thinking or even telling that this judgment is erroneous. No problem on that. Until and unless it is not a malafide attack. You can criticize the judgment, no problem on that. But that cannot be a ground to hold that decision willful. Then it will be lawlessness. We are guided by rule of law.
Absolutely.
There is a judgment. The authority will think that no, this judgment is not correct, so therefore will not implement. Is it not an willful violation? You can say it's a non-implementable judgment. Okay, that we can understand. That we cannot. We have asked something which is impossible to do.
In fact, the authority, they just want to verify. They have in fact taken an action, a process to see why the CID report and the state level committee's recommendation are contrary.
So therefore, let us complete all this. Let us complete all this and let the High Court judgment be not implemented or waited.
No. We have. Therefore, we have the department has taken a step to see whether the inquiry has been done, conducted properly or
See, we are not stopping you.
that report has come now.
No, your
So
ground is that history will not forgive you if you implement the court's order because you are doing an exercise.
No, no.
According to you, that was a historical blunder. So history will not forget you. We are not concerned with who will forgive you or who will not. But we are not going to forgive you.
Kindly Stephen, the very basis for passing the order dated 17 to 2023. This time I am reading two paragraphs of that order. So paragraph 9 of that order, 17 to 2023. Mr. So in the contempt petition itself, it is page 14. Mr. The learned senior counsel for the petitioner submitted that the continuation of the suspension order dated 12/3/2022 is bad in law for two reasons. Firstly, the very edifice upon which the suspension
Where are you
order
reading? Okay, that judgment.
Which
you have already filed a review.
No. This is the judgment where
Which you want an implementation.
which follow the contempt petition has been filed alleging violation.
Mr. Das, you will be here. Mr. Chaudhuri is there for the petitioner. We want your assistance. Just listen to the argument of Mr. Das, Mr. Nat, and assist us. What procedure? We are satisfied till now that this man has committed contempt, absolute contempt, and every moment he is doing contempt of this court's order. So we want your assistance. Just brief fact is like this: a judgment was passed, and a recommendation of a state level committee, SCST. What do you call it, Mr. Not SCST, something committee.
State level scrutiny committee.
State level scrutiny committee has, on the complaint of somebody XYZ.
I think my lord may have some problem because he appeared for the other side in this before the court. And we don't
No, still he can.
I'm just pointing out.
So that whatever done is done. A cancellation of SC certificate that was set aside by a learned civil judge, a coordinate bench. Now the person was put under suspension. Since original the basis was set aside by this court, a coordinate bench said that there is no need for continuity of the suspension. Set aside, reinstated him forthwith. This is the second order. Now that order has not been complied with. A contempt. We have taken a prima facie view or a suggestive view, not finality, that there is an absolute contempt. For the reason, they have given some explanation. Explanation is that the original order of challenging the committee's decision and set aside by the High Court was taken to an appeal by a third party. That appeal was dismissed. No, that attained finality. Now state want to file a review in that appeal. It is already filed in the original. So therefore, they say that there is some error in passing the original judgment. These are the grounds apparent on the face of the record. Therefore, they will not implement the second suspension order, the High Court's order. And their statement is that history will not forgive them if they reinstate. So therefore, since history will not forgive them, they are sitting over the judgment. More or less, we are having an opinion that it is not only contempt of the earlier order is clear, but the statement that they are not implementing for the reason that history will not forgive them itself amounts to an willful disobedience of this court's order, and the dignity of this court has been violated or particular.
Maybe there to be in appearing in this case, but what I understand, any order passed by the court, and if there is an order forthwith, immediately, irrespective you file a review or an appeal, that has to be complied. Within that particular period, that's my understanding. That's my understanding. That
You be here for a time being because we do not want to do any mistake in sending or whatever we need to. Yes, not.
Well, I was reading paragraph 9
Hmm.
of the of the order
Hmm.
dated 17th of February 2023.
Page
Page 88, Lordship will find it the additional evidence, or page 14 in the main content.
88.
Page 88. Para 9 onwards.
Correct.
Para 9. Look, Mr. So-and-so, learned senior counsel for the petitioner submitted that continuation of the suspension order dated 12/3/2021 is bad in law for two reasons. Firstly, the very edifice upon which the suspension order was passed is no longer in existence in view of setting aside of the order dated 26/2/2021 by this court by order dated 24/11/2022 in WPC number 2286 of 2021. Further, to that, the Deputy Commissioner has also revoked the earlier cancellation of the OBC certificate and has clarified that the state OBC certificate to be registered as valid. So this is the main ground. Sir.
No, why, Mr. Nath? Why are you reading all this?
Well, my
What do you want to
well,
say
I-
reading this?
well, I am trying to place your logic
Hmm.
that the very edifice which was
We understand. I have summarized your argument that your whole ground is that the judgment was passed on an erroneous fact or understanding or on the basis of a report who is having no sanctity under law
well, that inquiry report
is
ultimately-
absolutely bad. And on
ultimately-
the basis of that inquiry report, it was set aside.
Yes.
So what are you proposing arguing there?
My supposition is that since the inquiry report was found to be a perfunctory nature, the state has already filed a review petition. Review is pending, and the again I on last occasion submitted before your lordship that the file has been again placed before the competent authority for reinstatement. It was placed at one point of time. I have already indicated. Second, again it is placed. Now the authority has said that to prefer a review petition in this order also, and to grant us some time to in the
What sometime?
to take the appropriate steps in the
What appropriate steps? Tell us that we need to reinstate him 2 days. We are allowing you. Make the statement. He is here. That will take 2 days time to issue the reinstatement order. Tell us that. If that is the position, fine. Otherwise, we are drawing a contempt and fixing it day after tomorrow. Let him file by affidavit today or his explanation, and then after on Friday we are passing an order. Enough is enough.
Let me just
Add to
discussion.
Add to whatever consultation you need, you make it. Otherwise, these people will sit over everybody's head.
We have already started.
No, will not allow.
Should not.
Will not allow.
Should not.
We are as strict. You have seen, I think, in the issuing notice. Even in contempt, we are very strict issuing notice. At the same time, it's not that enough is enough. Time has come. This is not the way. You take care of your own history.
Supreme Court has stated, my lord, even if the order is wrong, this is judgment, my lord. They have to follow.
Look, see the audacity.
Para 7.
See the audacity. They are saying, and Mr. Nath, you are arguing that you are having a satisfaction that earlier judgments were wrong. No, you are every right to have that satisfaction. No problem on it.
My submission is that
suppose I pass an order, you have all the right to have a satisfaction that this order is wrong. You have remedy. You will not offer remedy for months, and you will say that history will not forgive us. Therefore, we are not complying this order. We are not.
The report has come in the month of November.
Understand. Understand. But first of all, you will have to reinstate him. Have whatever you like. But it cannot be a ground that you will not reinstate him because according to our understanding, everything is bad. You cannot decide whether this court is right or wrong.
Exactly.
There is somebody else to decide that. That will not allow.
Kindly come to para 7. fifth line, the sentence starting with the court exercising as your lordship got it.
Paragraph
Fifth line
7.
of para 7.
Okay.
From top.
The court
The
exercise.
court exercising contempt jurisdiction is primarily concerned with the question of contumacious conduct of a party who is alleged to have committed default in complying with the direction in the judgment or court order. If there was no ambiguity, indefiniteness in the order, it is legally tenable. Such a question has necessarily to be agitated before the higher court. The court exercising contempt jurisdiction cannot take upon itself power to decide the original proceeding in a manner not dealt with by the court passing the judgment or the order. Right or wrong, the order has to be. Even lordships will not also go into the contention which my learned friend is advancing, that this should have been done, that should have been the basis. End of the day, my lord, this is necessity of the law.
Majesty, otherwise
And
nothing will
secondly,
come.
my lord, why they didn't file a review in this case? They filed a review in another proceeding. If they would have filed a review in this case also, things would have been different. And well, all right. Earlier proceeding was wrong. You can restate that. They can also, you can take action.
Exactly.
If you have to recall history, there are so many other aspects where history should forgive. I mean,
Okay.
and my lord,
Had to.
and personal appearance, the lordship gave on 13 and 14 this order was again to the petitioner to appear for another inspection. My lord, it's something like after an acquittal has been approved by an appellate court, my lord, the police investigation has again been started. Something like that.
No, after having knowledge of the perfunctory nature of the report,
We'll deal with it. We'll deal with it. We'll deal with it. We'll deal with it. Since you are insisting on that, we'll deal with it. How we know how to deal with that.
That is why the review petition has been filed. I'm just making submitting.
No. Contempt, if you are insisting on that, either you
No, I'm not insisting on that.
Application. My lord, your lordship has I may be in this side, while learned friend that side, but your lordship has to deal very seriously.
yes, sir.
Because it is court and contempt.
Time and again, my learned friend is referring to the inquiry by the vigilance officer. Please come to page 83, my lord. Observation.
No, we'll not go. We'll not look into all
One
this.
sentence, my lord. The testing. Please have a look at once, my lord. And this is the view of the division bench on that report. Para 15, page 83. Testing the report of, has a lot of got.
Page
Yeah,
15.
15. Testing the report of the vigilance officer, the inspector CID on touchstone of the principle laid down in case of Kumari Madhuri Patil, we find that inquiry report submitted by the inspector CID does not indicate even in the slightest that particulars given by the candidate were false or that the social status certificate had been fraudulently obtained. Now, my lord, some executive sitting in this pool, he will draw subjective satisfaction and they want to say this High Court is wrong. Division bench, my lord. And the Honorable Division Bench had the privilege of my lord going to the record which was produced. And Mr. Dhar was the counsel in the government counsel in that case. He was very much present all throughout. My lord, Kumari Madhuri Patil is the core as to how an inquiry is to be conducted, how it is to be determined, whether a certificate issued is genuine or fake. There is no other procedure, my lord. And how an inquiry will be conducted, that is also prescribed. And this inquiry officer did that, my lord, based on that.
In fact,
This relates to medical also. Medical.
No, my lord, SCA.
And
my lord, this is a certificate of 2006.
Page 97 indicates where the inquiry.
No, don't say about inquiry. We will not go to anything on this. We want
After the step of
our order to be implemented till to make a statement. You have time and you are at liberty to say that no, we are not going. We'll know how to handle this kind of situation and we'll handle it accordingly.
Let me.
Yes.
May please respond. Method if the responses are finally as per order dated 49/2023.
My lord, we have received the thing.
What is the issue here? Tell us first.
My lord, this Anganwadi worker, my lord, disappointment.
Now, what is the report?
My lord, I was supposed to file an affidavit.
Hmm.
My lord, I will, my lord, honestly, my lord, I'm just, this is illegible, my lord, whatever I have received, my lord. So I have asked them to get the original copy scanned and send it to me, my lord. This, my lord, I even cannot read, my lord.
Mr. Dhar, Learned Counsel for the state respondent, submits that pursuant to this court's order dated 28/2023, though he has received the record and the report, you has a report?
It's a report, my lord.
Report, though has received the report
My lord will indicate
regarding verification of the residence, status of residence of the petitioner and respondent number. The respondent number,
no, this is for the petition. This is for the petition.
petitioner, full stop. Petitioner. However, same is not legible as he has received a scanned copy. Accordingly, prays that he may be granted some more time to obtain a legible copy and,
And I
if
file-
necessary,
I will file
file the
affidavit.
affidavit or
Already, I have
okay,
drafted it.
to file an affidavit. Prayer is allowed. Please this matter on
after you finish.
after affidavit.
But it-
After view, give a
view,
date. 24, 25.
Prepared the case number and some in Friday matter. Maybe
What is the issue?
what I did and there 2001 without 25
Uh-huh.
date of appointment. There the third the date of appointment 23rd 2001. It was 25th June 2016. Because my one is the initial date of
Subsequently, you have been, after medical exams, you have been appointed.
Yes.
You are working now.
Yes.
But you want that
Yes.
since there is a mistake, your initial date of appointment should be treated from the original date for the purpose of seniority and all. That is, yes,
maybe I could not prepare, but if I
2018.
Even I fall is Friday, my lord, for which I was on bed rest till today.
Okay.
That's why.
Uh, okay, I will give it date. MSA Guyon, learned CGSC. Prays for a last chance to file affidavit or what?
No, I have filed it.
Now you want,
Yes,
okay.
but
okay, submits that she is not properly thoroughly prepared in this matter as she has been suffering from some ailment. Accordingly, she prays for an examination. Prayer is allowed. Please this matter on give a date of immediately after vacation, 2018 matter,
we take 4th or 9th
9th of January 2020.
month.
Yes, Gan, what is this?
And he fixed it immediately after 18.
What is the issue here? Can I turn Mr. MSK Gayan, learned CGSC, prays for an accommodation for today at 6 and adjournment. Prayer is allowed. Please this matter on 9th. Be ready on the day.
Yes,
His last occasion, Lordship, records were called for, Lordship.
Hmm.
Not received the records, Lordship. If we ask for the
What is the issue here?
My lord, it's the proposal matter. Petitioner was cleared during the training period, my lord. And according to the code of inquiry, my lord, the jury is attributable to the government.
Okay.
But his proposal was not the medical side. So that's why I
our contention,
Affidavit file.
affidavit file,
What is
Lordship,
the stand in the
stand
affidavit?
in the affidavit, Lordship, that he never sustained the injury and not attributable to the
There
Okay,
was
but
this
from which
Court of
document you
Inquiry.
want to say?
That is opinion of the Court of Inquiry
Where is that?
by petition page number 25.
Now, what kind of record is required for this?
For medical record, court was asked for the medical report at that point of time, 2005 records were called. Because we have stated that the Court of Inquiry was not done properly. In our specific stand was that.
Suppose court of inquiry was not done properly. What have you done properly then? Thereafter,
That record,
have you, and then what is the basis of subsequent your decision in ignoring the medical, the court of inquiry? If you ignore court of inquiry, then what should be your basis? Do you need record for that? A court has passed an order for record. Mr. S.S. Roy, learned CGC, prays that he may be granted guarded further 10 days further time to obtain the record in terms of this court's order dated 9/10/2022. There is allowed list the matter in the second week of January.
Yeah.
It will come 2019. It will not be. We have instruction. This matter should be.
keep it. Oblige.
Yes, Mr. Suri, what is this?
My lord, the issue involved in this case is
Hmm.
whether more than advertised vacancies can be filled up.
Hmm.
My lord, in case of direct recruitment, it is 100% foolproof. I mean, yes, that it will.
Hmm.
But to what extent that principle will apply in case of a promotional? Now, what has happened in this case, my lord?
Now, is this a case to be heard and disposed of before vacation?
Not that necessary. Not necessary. Yes. Also, can have it in the, my lord, any date after 7th of February.
Okay.
May I pray in the January, your lordship, because
January,
as of now, 52 posts are there. The petitioners are admittedly, they have not passed the departmental examination. We have passed the departmental examination. In spite of that, we are not being promoted here.
Have you any stay order?
No, stay order was vacated, and thereafter they went
filed
into
a
the writ
writ
appeal.
appeal.
Matter was remanded back.
Initially, there was a stay. That stay was vacated. Then we approached the, my lord, division bench. Division bench said, my lord, should be the discretion of the government to give or not. That is how the matter. The division bench order is holding till the disposal of.
The
No,
issue
my
is
lord, it's a question to be gone into whether in a promotional
It's
exercise.
an important legal issue. That's
that
why I
whether
said that is it
that
a
brings
case
it-
before
No, no,
vacation?
certainly not.
In fact, your lordship, this writ petition is not maintainable on the count that this petitioner.
So you want that we should proceed today?
No, I'm not saying that. So
If
may
you
I
are not saying, then let us not waste time. This is my idea. I do not know.
Yes, yes.
That's why I asked, after hearing 15 minutes, then adjourning it instead of doing that.
Rasif can have it in the my landed
This is express
on
urgent-
January.
Ah.
January before 19th, any date.
Yes. Okay. As agreed to give a date Tuesday or.
Okay, Peter,
is there a law?
no.
Oh, sorry.
19 sir.
Apna biar. Chalo February karo. Sir, your lordship, let it come.
अब 18.
18th of
19
January.
क्या है?
As agreed to by the. Please.
Deeply obliged.
That is necessary also.
Yeah.
Yes, what is this, Mr. Dhar? Hmm. Just a minute. Ready?
My lord, one is delay. My lord, in
Oh, delay in pension.
delay not is not entitled as per
That
the
you
rule.
can say, but if you say that delay is in pension, then it will be difficult.
My lord, no, my lord, he is not.
He's not
that
entitled. According not entitled. Okay, let us decide it. Yes. Tell us the dates. Hmm?
Is 20 and 20.
Yes.
20 and 21. Discharge,
Impugn order.
discharge order. So almost we have that, but suddenly he developed a disease. But they have some medical differences.
Page 21.
Critical case number 26,
Page
22.
22. Yes.
Page 24, return for discharge, etiquette, invalid, ransom. The doctor have etiquette, invalid, ransom.
Okay, then. Mm-hmm. Where is that? Where do you get page 27? Where do you get page 27? Part 3. You raise your voice, I am not hearing anything.
Ethica 500, page 27.
Page 27. Just a minute. Page 20. Just yes. Mm.
Estimated death per protein and was just service after entering 8 days of that of for safety and not effective not effective service time. Yes, to that could be executed or executed and to
What is the original order of discharge? Page 21.
yes, is 21 is that one 24
24. Page 24 says your character is exemplary.
done for that invalid.
So your pension has been granted, invalid pension.
That
Let As per rule, my lord, to get invalid family pension, he must complete qualifying service period of 10 years earlier of it. But he has completed eight years. job.
So according to you, a person, according to the rule, a person who serves the court and is invalidated within 8 years for reasons attributable to the condition of service is not entitled for pension. So you can take his life and don't give pension. Can that be a rule? Where is that rule?
My lord, before that, my lord, that he was discussed in 1991. His writ petition is filed after 19 years.
Okay.
And the representation also submitted after 18 years, my lord. But we have paid the amount what he was entitled to.
What was he entitled?
Yes, I have.
So your first contention that this is not could not be entertained because of the delay.
We have paid.
Okay, that ground, my answer is this. The law is well settled that pension, non-payment of pension is a continuous or having a continuous cause of action. Every date pension is not paid creates a cause of action as held by Honorable Apex Court insurance over substantial. Therefore, such contention is rejected. Yes,
But,
come to the next.
After 19, my lord, after 19, it was taken away, my lord. That one person engaged in the appointed in the post, he must get family pension or pension, and monthly pension is entitled. But before that, my lord, he has to complete 10 years of service.
What is the truth? What's that?
I have stated in details in a paragraph.
No, you want to see the rule. Which rule? Which provision of that rule?
My lord, at 58, my lord.
At page
58.
This is understanding.
Rule 49.
Page 58.
58, my lord. Rule 49. Teacher 72. Oh, 58, my lord. Sorry. 58.
58.
Yeah. '49. That's all. It is a relevant for 49 amount of one
rule
1 49 amount of pension.
That is not a pension. That is a invalid pension.
My lord, here it is stated that in case of all my lord, in case of a government servant retiring in accordance with the provisions of this rule before completing qualifying service of 10 years, the amount of service gratuity shall be calculated at a rate of half month.
This is a calculation of gratuity. Where is that a pension, a invalid pension, a person is not entitled for invalid pension on medical ground if not completion of 10 years? Where is that rule?
My lord, next page, my lord, 59. This is the digits mean for 3A. 3A, next page, my lord, 59.
Hmm.
3A. Disablement shall be accepted as due to government service provided that it is certified that it is due to own injury or disease which is attributable to government service. His disease was not attributable for government service.
Yes, madam. There are some recent judgment where says that these are the conditions in the
30th, 30th, that
yes, read it.
really pension may be granted
Rule
38,
rule
rule 38,
of CCS pension rule. Read it.
really pension may be granted where government have declared the service on impossibility or that family who is permanently interested in product. But one shot that time, that
Fever. Which part you want to rely? Ah,
four.
that we have seen now. This is for injury. This is not the injury. Para 5 of? Okay, para 5. As per rule 30 rules.
Which one? That is the direct
But how you ensure that they have annexed a medical report which says that they say this is not attributable to the service? What you say about that?
I have for night reported I got every I got after I developed reported
But can this court presume that no, this is because of the it is attributable to the service?
and while the rule 38 also does say
My lord, the appointment, my lord, after 3 years he developed his disease and under medical treatment for another 5 years, my lord. In this way, he completed 3 years.
Where is that? You have issued a discharge certificate saying that his service was exemplary and that he is entitled for medical. Why should he believe subsequent records? That is the end of the matter.
My lord, at page 50, my no. Mail 49, my lord, medical board proceeding.
I have seen that.
My lord, another is that it was taken up by the condition. Okay. By notification dated 4th January 2019. I have annexed in 61 at page 61. It is the English version is at 63. this rule may be called Central Civil Service Pension Amendment Rule 2000.
Where is your record
And next
regarding
page
this?
two.
Where is your record regarding this medical examination?
Record is not there, but I have details that this was the first 49 was issued in February 1991, and detailed report is not there. The next page 50 also. June 1988. 50. It's clear from that he was suffering from 1998 after three. The opinion of the I am opined. I am of the opinion that the rifleman is not fit for to be a soldier, and
Perverse.
and
Perverse. Even we can say these findings is perverse. See your finding it, and then, madam, you are not even taking this court call. We'll take on our own. Mm-hmm.
Yes, yes.
What it says?
Please don't touch.
Where was the opinion?
opinion
It's
page
26. It's 54.
50, my
Huh?
50.
So 50 it starts. Statement of the case, part 2. Isn't it?
My lord, 49 is the medical board proceedings, invalidation, and 49, and 50 also opinion.
It's a good case. Where is part 3?
But is at page 54. Non-organic in the fourth paragraph. 4 mark. Non-organic organic psychosis 45.
Okay. Yes, madam, what you say?
As per extraordinary requirement,
Huh? No, that is not the issue. Here, my case is that this is non-attributable. Family pension, invalid medical pension, a person is enter. Forget about the time being for the period. We accept your argument that there is no period for granting invalid pension. Okay. But what is their case is that you will be entitled for invalid pension when the service condition attributes to the disease. According to them, it is not. Now, what is your argument on that?
my reply is to 30th extraordinary
Yes. Which are your rule? According to you, no attribution is required. Where is the provision of granting invalid medical pension?
The disablement shall be accepted as due to service provided it is certified that it is due to injury or disease for one which is attributable
That
to
is the issue.
my lord next one or exists before or arose during the government service and has been remains aggravated. It is existed or after death as per rule 38.
You tell us the rule. Rule 38. Rule 38. And
Rule 38 A2. Yes, that's it.
okay. Yes, my friend. Okay, we'll come back at 2.
But I but this I got the Lord, kindly,
Having the aforesaid satisfaction,
Lord, Lord, this report I, Lord, we could not take up it because he is the honorable chief minister of the state. Kindly give us to the
having satisfaction,
let him
having the aforesaid satisfaction, the contempt is drawn against the petitioner, and a notice is issued returnable on Wednesday, on which date, if the petitioner, if the respondent so advise, may file an affidavit on point of sentence. Please this matter, day Wednesday.
can it be taken on Thursday?
Thursday.
Because after this we cannot take up, and this authority is not the ultimately the authority who
We
is in
do
a
not know as per the affidavit whatsoever is there. Who is he?
He is the secretary. Ultimately, Lordship has seen that the competent authority has not approved. That is why he is not in a position to file.
We do not know. You give that reason, we'll see. That is not that cannot be a reason. That cannot be. So do you want that we should draw a contempt regarding this also? Do you want us to go to that extent? Don't show us this kind of document. We are not expressing any opinion.
On
Mr. Das, you be present
on Thursday.
on Thursday. Respondent. That the respondent Spencer shall remain present on that day at 10:15. Yes. Which law? Any judgment you want to rely? No. Very good. Ex Havildar Maniram Bhera versus Union of India. Give the second.
Pension rule 1972 is applicable.
What applicable?
Pension rule 1970. This year 72. This is there's the speech memorandum at page.
No assistance. Ex-CFN Nursing Jadab. Ex-CFN Nursing Jadab versus Union of India. Civil appeal number 7672 of 2019 decided on 3/10/2019. Okay. In Union of India versus ex-Sepoy SCP R. Munnuswamy. Munnuswamy. Sepoy SCP ex SCP dot R. dot Munnuswamy MUNUSAMY. Okay, list this matter for further hearing. Yes, what is your case? They say that it is not attributable to your case. What is your argument on that? Can you sit over the decision of the applicant? Huh? Rule says it should be attributable. You are relying on which rule? Rule 38 of CCA pension rule. Then rule extraordinary pension rule. Which rule? Three A. Five disability pension category. Family pension for category disability category. Was which is the true? Market. And what is your case?
As per office memorandum, this is 12 February 2019, man. Annex 65.
Annex 65 or page 65?
Page 65.
What it says?
Page 65 of my application. Grant of invalid pension under Rule 38 of the CCA service, Central Service Central Civil Service Pension Rules 1970 clarification. Clarification.
Page 65.
Is directed to say that Rule 38 and Rule 49 of the Central Civil Services Pension Rules 97 have been amended and by notification dated notification number dated 4th January 2019 copy to the provisions of to the amended Rule 38 of the CCS pension rules provide that a government servant who retires from service on account of any bodily or mental infirmity who is permanently incapacitated from the service before completing qualifying service of 10 years may also be granted invalid pension in accordance with sub-rule 2 of Rule 49, subject to the condition that the government servant, next B, my lord, fulfill all other conditions mentioned in this rule for grant of invalid pension. And 49 is also, I have annexed, my lord, at page 58.
What is the other condition?
Other conditions, my lord, just this is here. This is explained. What is this? Here, the disablement shall be accepted as due to government service. Free, my lord.
What is the law in this regard?
That that disease which is attributable to government service.
What is the parameter that has been laid down by Supreme Court regarding this attribution aspect?
Is decided by the medical board, man.
So medical board authority is the final. What is the law in this regard?
Medical board is final.
Final.
Because it is accepted by here rule is there.
There is no other parameter. Medical board will say that this is not attributable or attributable matter, and there is no other parameter.
My lord, termination of service to honorable person on ground of unsuitability. This is the act, my lord. And where a commandant is satisfied that an enrolled person is unsuitable to be retained in service, the enrollment person shall be so informed. One is with the particulars of all matters advised to him and call upon to any region he may wish to put forward in favor of his retention in the service, provided clause such and such shall not be applicable. If the commandant is satisfied that for reason to be recorded in writing, it is not expedient to and or reasonable practicable to comply with the provisions of thereof, provided further that the commandant may not furnish to the annual person any matter adverse to him, if in his opinion
how that is relevant. What are you doing?
The commandant may refer to the medical board.
So commandant refer to the medical board. Medical board says yes, no, attributable, not attributable.
They examine it.
Now, what is the principle that it is to be determined as attributable or not attributable? Any law laid down in this regard? Madam, are you aware? We are not interested in looking at your faces. We'll do our job. For it. What are they?
20.
May I?
Yes.
My lord, petitioners are appointed, my lord, as per Assam Public Services Preferential Appointment Rule 1999. They ought to have been appointed regularly, but they have appointed in a quarter. But
Are you having any right under the act?
yes, my lord.
To get appointed?
Under the rules, my lord, appointment.
On last position, my lord,
My lord, they were appointed in 2000. They are before your lordship in 2020. My lord, I have received instructions, my lord. They cannot be regularized. That is what I will bring this on affidavit.
No, first of
let
all,
them file affidavit, ma'am.
Huh?
Let them file affidavit.
That is what my lord they say. The instruction is.
you have been directly appointed under the scheme. Any
Yes.
power, Mr. Thor? Do you have any power to appoint directly without selection? Because they are only getting preference.
That is
All are all mess that has been created by you only, none other.
20 years back, my lord. Yes.
We do not know. We know the state, whether 20
Yes, my
years.
lord. Yes, my lord. It is a state,
Mr.
my lord.
Thor submits that he may be allowed, he has received, Mr. Thor submits that he has received instruction accordingly. He may be granted
2 weeks back.
2 weeks time. Simply lick it up, Mr. Thor, please, for list the weeks.
What time?
Why? What is the issue? Huh?
But I put number.
What is the issue?
So, my lord, this, second round of litigation, my lord. Initially, there is an order, my lord, this honorable court to examine this whether he is suitable for re-employment in the CRPF. Because, my lord, during the initial training, my lord, basic training, he injured me. And thereafter, he was, my lord, terminated. Then this, he filed this on first petition, my lord. It was observed that disability board is there, to directly consider whether he is.
So what is the finding of disability board?
My lord, he is not considered, my lord. Accordingly, my lord, it is rejected. So thereafter, my lord, again this petition is filed, my lord. And initially, my lord, the termination order is not set aside, my lord. Initial request. So the termination is order is then, my lord. So under the when it was before the honorable court, my lord, it was.
Have you filed affidavit?
Yes, my lord.
Okay, after vacation we'll hear it. First one. Timing.
I also in court number 76.
We do not know how you manage.
Yes. Wait, please, your lordship. Lord, the consent for the couldn't bear me.
What is the issue?
Lord, not getting appointment. The petitioner, my lord, applied for the post of constable, my lord, in civil category, but he qualified all the. Yes. But he didn't get
When you want?
vacation.
On the Metro stands on the prayer of the learned counsel for the petitioner, Metro stands adjourned and be listed upon. What is this?
Affidavit in opposition was filed by respondent number 3 to 6, to which we have filed an affidavit in reply. Now, here, leaving aside the dispute, one thing, my lord, if your lordship considers.
Before leaving aside the dispute, let us know the dispute.
My lord, dispute is.
We'll leave it aside after understanding what is it.
The petitioner was appointed in the year 1974 in Artpet. Now, he retired in the year 2017. During his service tenure, he served in several branches of Artpet, where salaries accrued but were not paid, were not released. So they are accrued arrears salaries. Arrears salaries to the extent of 13 lakh 24,000. After superannuation, he prayed for releasing the said amount. Only a meager sum was released. It is an admitted position of fact that major chunk of the arrears salary has not been released. They have filed an affidavit saying whatever has been claimed by me, out of that,
they have admitted an amount, not exactly what I have claimed, but they have admitted an amount. I'll not go into that dispute because that will amount to disputed question of fact. Whatever they have admitted in their affidavit of 10,44,000. Let them pay it within time bound manner. I'm not asking for anything else.
At present, when we are facing financial difficulties.
It's a corporation.
Yes, arbitrament.
Let it wind up. Let it get wind up. Are your managing director getting salary?
Well, presently, well, there is no permanent managing director. At that, is in charge managing director, who is presently the director of handling. Is the in charge.
Can this be an excuse? 2008-7 is this.
Where is the stand affidavit? Stand in affidavit.
My lord, from I have, my lord, their stand is from paragraph number 8 to 17. They have given a calculation.
Space.
My
Page 69, my lord, we have given a statement.
Page 69.
Page 50, paragraph 16 will do, ma'am. Page 50, paragraph 16. This is what they say is outstanding.
Page.
Page 50.
Page 50.
And paragraph number 16. And they have an accepted. The amount at the right at the end of the paragraph. This is what they are admitting. Let them pay it within 3 months. I have waited for my lord since 2010.
Yes, when can you pay? Arcade is also this situation. Mr. Dhar, you are handloom textile. Arcade is also this condition. They are having good showrooms everywhere.
That because of very loss, which we are
Private players are some is arcades are being appreciated everywhere. Isn't it? You had also huge campaign. Isn't it? Yes, when can you pay? You have we are recording it. This affidavit. You have a specific instruction with how you propose to pay. Give a proposal.
We have already submitted the proposal to the government.
Forget about it. What is your proposal? How to pay it? What is your
3 months time?
3 months? We are giving you 5 months.
I will not update.
We are giving you 5 months. Or you want 6 months. But on the next, if any contempt is filed, then you will be in difficulty. Hard Chakraborty learned counsel. Also hard Mr. A. Zahid, learned counsel appearing on behalf of respondent number 326 and Mr. Thor, learned counsel appearing for 1 and 2. The grievance of the petitioner is that the claim of the petitioner is that his employer, namely his employer, that is respondent number 326, respondent number 326 owes him an amount of rupees 23,38,393.17 against outstanding salary What is this compensation?
13 lakh 24 negative.
13 lakhs 24,000.
490.
You file like a suit, Mr. Chakraborty.
But whatever comes on my side, I'll take.
13 lakh 24,493 against the outstanding salary due. The respondents, the petitioner, according to the petitioner, petitioner has been persuading this with the respondent authorities. However, the respondent had failed to honor his due. The respondent has filed an affidavit wherein specific stand has been taken that the total outstanding due to the petitioner is only 10,44,845.
10 lakh.
10 lakhs 44,845 only, and not 13 lakhs 24,000 as claimed by the petitioner. Another specific stand was taken that while admitting while admitting such due, yet another stand has been taken that due to severe financial crisis faced by the ARTFED, ARTFED, capital, all capital, the petitioner could not be paid. And that the state fed, ARTFED is not in a position to pay the admitted amount at the current situation. Full stop. This court is of the view that on instrumentalities of state like the ARTFED, when admits the due of the of an employee, due salary of an employee, cannot take a stand to deny such right due to paucity of funds. At this stage, the learned counsel for the ARTFED submits that a proposal has been sent to the government for release of money due against the petitioner as well as some other employees, and it will take 3 months time to get such approval from the government. Then only the ARTFED shall be in position to pay such amount. Therefore, he prays that a period of 3 months may be granted to make such payment. Full stop. Considering the above submission and the specific stand taken on oath in an affidavit as discussed here in the above, this court is of the view that the petitioner is able to make out a case for direction to the respondent to pay the outstanding admitted due of 10,44,845 to the petitioner. Full stop. Accordingly, it is directed that the respondent ARTFED in the component number 3 to 6 shall do the needful for payment of the petitioner amounting to rupees 10,44,222 within a period of 6 months from today. 6 months from today. 6 months from today. We'll say them they may pay in installment also. The respondent may also pay the aforesaid amount in installment to the petitioner within the period fixed as above. With the proceed, the present writ petition stands. I think. Yes. Affidavit in opposition, reply. File.
We have filed, but so far the affidavit in opposition is concerned, the body of the content they have reflected but they
Well,
have only- they have
there is a mistake on my part.
That-
What
that
happened?
annex
Seven
has not been
annexer,
supplied.
annexer number 6 is a part of the writ petition. And annexer number 7 is a judgment of Delhi High Court regarding same issue. After review medical court.
Is it not necessary?
Well, it can be I can produce for your.
You give a copy to
My
him,
lord.
full copy. Okay. The learned counsel for the, because they need space. If you want to argue this case, if you rely on your affidavit, in the court's copy also that is not there.
That is
then you'll have to file a press.
It will take time. My lord, this is the judgment. It's a 2-page judgment.
Mr. Goswami, we understand that that is a 2-page judgment. We have no problem if you rely on that. If you make a part of your affidavit, is it not, it should not be the record. If you rely on a judgment, give it to us, that is no issue. But if that is a part of your affidavit.
The statement made about this judgment. The judgment somehow it was not connected with.
No. Is it an annexer to your affidavit of position?
Well,
then.
And another aspect of the matter is annexer 6, which is mentioned in the affidavit of position. That is a part of the writ petition. That is also annexed in the writ petition.
No, that we understand. Is it a part of your affidavit?
Malo.
Then you will have to withdraw and file it. Yes. There must be a discipline.
Malo.
Learned Mr. Goswami, learned counsel for the respondent submits that some annexers, two annexers, two annexers, namely annexer 6 and 7, appended to the affidavit in opposition filed by respondent number 1 to 6 has not been annexed with the affidavit in opposition by inadvertent mistake. Accordingly, the administrator and he may be allowed to rectify such defect. Accordingly, the affidavit filed by the respondent number 1 to 6.
It is let it remain here.
No, that
file
cannot.
additional affidavit for being it.
No, that cannot.
Let
you listen to the order. We will have to follow some discipline. It's not that somebody will come and annex and file an additional affidavit. That is not permissible. It will be a record. It's a high court is a court of record. It will remain for all time to come. Is allowed to be withdrawn from the file and is allowed to file it afresh after making the after correcting the list after. Any urgency?
After 1 month, because I have to obtain the form.
In the month of second week of January.
Let it be third week, because
third week
it
of
will take time.
Third week of
Highly.
How registry can accept this, we do not understand. Not passed. Everywhere chaos. How registry can pass this?
Your Lordship, I placed one inspection to the revenue department.
What is your decision? According to him, state level committee recommended and SLC was not taking up the matter. This is your case?
No,
DLC recommend.
DLC recommended.
he also has
So
rejected.
SLC was not sitting over this matter.
No, madam. SLC has rejected on the ground that 2 posts has been filled up.
Okay, now
Now, actually, they on the last occasion from the deputy commissioner,
Hmm.
they admitted that there was a mistake,
Hmm.
and it would be placed before the next essay. They forwarded to the SLC, the department. Now, the department has said that yes, we have this instruction dated.
no, what is the prayer in this writ petition?
Prior to appointment of the compassionate petitioner, a widow before your lordship, and widow's husband has expired while in service. Thereafter, the maiden application was before the DLC, and DLC has
When she expired? When the husband expired?
my lord,
13/1/2017.
13.
And when this DLC recommended?
Twice.
Twice, my lord. Earlier, my lord, there was some mistake. 17/7/2017, and my lord, 14/12/2019.
17? 19. Then when this was rejected?
Reject on 27/11/20.
On the ground of?
On the ground
want of vacancy.
Want of vacancy.
Now, what is your why should we set aside that?
My lord, our submission is this, my lord. As on today, my lord, the petitioner case is governed by the, my lord, 15 notification. The 15 notification, my lord, there is a provision that if the particular area, my lord, posts are not available, my lord, then his or her case can be taken up for any other department,
What should be the limit of that period?
some other department. That is
No,
the-
understand. For how long you can be put under a waiting list?
That's broad, my lord.
Huh?
Otherwise, we are pursuing the matter, my lord, since after date, my lord.
That is the difficulty. You know the law. List
Now-
after vacation.
Now, my lord, my learned has brought a notification to the inspector saying that they are now going to consider the nail package. So, the lord, can dispose of the matter since the data is brought, my lord.
Will not issue a direction to do the same once again. If they do, let them do it or after vacation. Compassion should be there, but the compassion is time limited by declaration of law, by operation of office memorandum.
That's right.
So compassion cannot go beyond. That is a binding.
That's right.
Is
I
that
do say admit. The only thing is this because of not our fault, my lord.
That
Because
we
of the
understand. Now the recent trend of the judgment is the delay including SLC, DLC, even the court. Devabrata PR. These are binding precedent. Says that his purpose is fulfilled. Immediacy is the criteria. When immediacy is lost,
Immediate assistance.
everything is lost. Therefore, you file a suit and seek a compensation that for you, my case was not considered. List of the vacation as agreed to by the learned counsel.
May I please, Your Lordship? First, in this matter, we are filing additional affidavit, my lord, today, my lord. So, mathematically,
Additional affidavit in opposition. What is the issue here?
regarding promotion,
Motion matter, regarding matter, common graduation list, because matter, before lordship, we are matter under DID. Subsequently, matter, as per government, matter.
That you have been absorbed, no?
Yes. Now, we want for matter, common graduation list.
They have a case.
our intention is that, my lord, as they were not holding the government post, my lord, earlier, if we will not protect them, my lord, then they will go to the to the list, my lord. Because they were not government employees.
No, they are now government employees.
Yes.
Do you
After
propose
absorption,
to say that they are a different class of government employees? So therefore,
DRDA was this society, my lord.
no, we understand. You have absorbed them in the DRDA.
Yes.
So your case should be easy. Your case is that their seniority or
Yes,
class should be considered from the date of their
yes,
absorbed.
that is correct. And for their right, my lord, we are government.
Okay, what
notify-
kind of additional affidavit?
Clarifying one calculation, my lord. In our affidavit, my lord.
Okay, Mr. The Learned Standing Council for the Panchayat and Rural Development submits that there are some errors.
Not errors, my lord. We are clarifying one
Okay,
calculation.
they need to file an additional affidavit in opposition to make certain clarifications. Clarifications regarding the pleading made in the additional in the affidavit in opposition. Mr. Kayum has not objected to such prayer accordingly. List this matter on
Immediately after the vacation.
not immediately. It will take some time. It will need the delivery.
Because of this case, my lord, the promotions are.
But you are delaying
Yes,
it. We could have decided to take. He is also in hurry. You are also in hurry. We
As
have
per
no problem.
lordship convenience.
January. As per your hard dates. Twenty-fifth of January.
Outline.
Yes, Mr. Monto.
This matter is otherwise ready for final disposal. And the issue relates to the reservation of the vacancies for the category of civil class vis-a-vis the physically handicapped person. Here, what happened? Your lordship kindly turn to page 25.
Page 20. Who is page 20?
This is the advertisement by the APSC.
Just a minute. What is the post?
Post is junior engineer civil under Panchayat and Rural Development Department. This next page 26 lordship will find this category.
Page advertisement?
Advertisement.
Yes.
Here, 344 posts have been shown, but ultimately it was reduced to 320. 324 posts were asked to be kept aside by an order of this one.
Okay.
The other. Therefore, they have confined it to 320. And on the basis of that calculation, they made a reservation. Lordship will find. Here, the table Lordship will find junior engineer civil and the left-hand column. And here,
Total 144 open category.
Open category.
What is RFW?
RFW is the reserve for women.
Okay.
Then reserve for OBC, MOBC. Then reserve for S. This is where by dispute related.
Okay.
13. Out of that, they have shown RFW 4 for women 4. And other category, we may skip over prototyping. Lordship will find right hand column extreme.
Total.
Post reserve for PWD and type of disability. That
Okay.
particular
Post
column.
reserve for PW or of any type of disability.
Yes.
14.
Yes. 14. Blindness. 4,
LV4,
LV4,
4,
D4,
locomotor 3, autism 3.
This 14 posts they have reserved. So we understand from this that these 14 posts reserved for all these have not shown which category, how many posts, which post is reserved for PWD.
You belong to which category?
I belong to SC.
Okay.
SC. Now disputed rules because here
we are going for disposal or what? Finally.
Because they were asked to produce certain records. If the lordship will find the order, if they are coming with all these records, they may place it, we may also look into. And then lordship may.
Yes, record is there.
Dear Lordship, however, Mr. P.P. Datta is appearing in this case and he would be better person to assess this court lordship with regards to record.
Yes, Mohanto, you are
Yeah, my lord, I have not gone through the record. Simply record was
PP doctor will assist you.
definitely my lord, but the record is with my lord. That they need that my lord. Record is there. They will see
Immediately
the
after vacation lordship court.
That's why I
Yes,
asked
I am sorry, my lord, because I have not gone through the record.
Mohanto.
I mean, the record is there.
Records, if there,
Okay,
they may give us also the
you
my lord,
show it to him, Mr. Let him see.
Yes,
Not
my
any
lord.
objection.
No, I don't have any objection, but regarding record, but I have not even gone through my,
No, you go through it.
my lord.
On the before the next day.
Yes, yes, definitely, definitely.
You also flag mark so that we
Yeah,
can
exactly.
understand properly
Exactly.
instead of
That's why my lord, but to that is your lordship, my lord, properly I have to come.
okay, then show it to them
My-
also so that they had
Otherwise, I am appearing for the department law. My urgency is that it's an advertisement of 2020 law.
there is stay.
Stay is offered. And against a person lordship who is a selected candidate.
Who is appearing for the selected? Okay, so there are some urgency.
Lordship is
When
result
Mr.
was
Monta immediately reopening.
My
lordship
my lord, even my lord, Friday, my lord, actually I have not.
No, Friday is fine
I-
for
I
Friday
understand.
is fine for you.
My-
If you want to say that I should write a
No, no,
judgment
no.
in the Xmas vacation, that
Third-
if you propose that, we'll hear it on Friday.
No, no,
If you say that,
on 4th or 5th. Lord.
not immediately on photo.
If-
They have waited, we have been waiting, we are.
no, see, we also
But all
feel bad
convenience
that
is-
when a selection process, either we set
Yes.
aside or
No, it's
let
a
it be
selection
given.
of 22 lot.
I'm also suffering because if
Ah.
I have to get, I will get it.
So let us give this case a preference. On
So,
third,
Not on 3rd, on 4th. On 4th.
fourth, we are
already over.
all fixed. That's why third is possible. Otherwise, it will go.
no, third
Huh?
will be reopening only.
Third is free.
Well, third is reopening only.
Ah,
May not be forbidden.
but we cannot say that it's reopening. Will not do anything.
I don't say, but for that is this case,
Lawyer can have that advantage, but not the judges.
this case may not be fixed on that day. Let it be on 6 or 10 or
No.
9.
See, we have fixed this kind of matters where urgency is there in the first week. Many matters.
Yes,
So where are the other dates?
4, 5, or 8,
8,
9,
9, 10.
8, 9, 8,
Yes,
8,
9 lot with Tuesday.
9th. Okay.
The lordship will keep this matter for disposal.
Are disposed. If record is there, go through it. Will it.
Otherwise,
This
the matter
selection-
is a decided matter. Law is there, notification is there, Supreme Court judgment is on.
we will see all that.
We made the
Doctor
selection
will
as per
consider
the
all that.
requirement of the government, my lord. I will place that
That is the
because I have to obey the how they have regarding reservation is my lord.
You are the selecting
My
authority.
lord.
Yes. How they have done it, that depends upon the what direction goes for.
Yes,
Yes,
they are
government.
just they will conduct.
Yeah.
But I think you have also role when it's
No,
suppose
it-
somebody
it is
says
not
that it's
considered
beyond
law.
rules.
I have
Then they should indicate it. They should write back.
yes. If they have violated the rule, then I can.
When
I-
has agreed to by the learned counsel for the parties is this matter on
9
9
for disposal.
for disposal.
Interim order shall continue.
Interim order or shall still continue till then.
Still lordship may say till hearing because it was hard several times, partly vacated, partly maintained.
Okay, we'll hear on that day.
Yes,
No worry. If discourse is will
Otherwise, what I say. Every time if we forget to extend it,
you will show your face at least that to extend the interim order.
well, it will
That's
be
why you
our
have fixed
failure.
it.
We hardly get an opportunity to appear. So definitely for that cause also we'll be happy to appear. But then for that portion.
No issue. We'll make it even if it is out time
Well,
positive time. You will ask her to
yes,
make a
yes,
mention.
they
We'll
will be here.
extend it.
They
Yes,
will-
next case.
Obliged.
Here we have received the instructions about, we would like to file an affidavit.
What is this issue? Issue? If
It is
short issue, we can decide it, or if
regular
it needs some deliberation, we can
Regularization.
regularization. How they are appointed? They are master role or what?
Master. Still available fee of that.
Who are this respondent?
That is other respondents probably at the hearing.
See, this is your problem, not the address given in the cost title does not correlate with the address in which the notices were delivered. As such, service is not complete. Take fresh steps in the proper address. Any interim order? No. The learned counsel for the petitioner submits that in view of the Lawajima Court order dated 29/11/2023, he may be permitted to take fresh steps upon proper fresh steps for issuance of notice upon respondent number 35 in his
25.
and proper address. Huh? Okay, I will look at the learned counsel for the petitioner prays that he may be granted 5 days time to file to take steps for issuance of notice upon respondent number 17, 25, and 30. In addition, the trustee is permitted to take to this registry file affidavit list of topics. Notice is made returnable for the list according.
My lord, in this matter, I have received instructions, my lord. Taking 2 weeks time, we will file affidavit.
That's considered.
If Thor says he will file,
Since
Is that it, Mr.
since
Dhar?
on January, Lordship, they took time to file it.
My lord,
Mr. Thor submits that though he has taken time on last occasion to file affidavit in opposition. No. The Mr. Dhar prays for further 2 weeks time as a last chance to file affidavit in opposition. Prayer is allowed. List after 2 weeks.
Fix the date.
Date will be difficult. You may say on that date I want to file a reply.
Already filed.
Yes. Last week we have filed.
Compassionate appointment, let it go after that.
My lord, I have already filed affidavit, and my lord, in fact, in my lord, in his post, my lord, probably in the there is a peon post vacant. He is applied
This
for
is High Court or what?
that is in family court.
my lord, I don't know.
Huh?
This has to be dismissed. The court has settled this recently, my lord.
Let me finish. He is died in 16. That term is it is term on 17.
No, not that. I am on law.
Okay,
What the problem is in peon post, his first mother applied, then daughter applied, son applied.
After becoming major.
After becoming major, but both of them are overqualified for that. Because in advertise, peon post nowadays advertise, he must be a class up above class 8, but below higher secondary. If he pass higher secondary, he is not eligible for a peon. In the advertisement is clearly mentioned. If he pass his double
no, but this is compassionate appointment.
My lord, in that case, there some advertisement has been, my lord. No, compassionate appointment, that particular institution post has to be, my lord, vacant. If no vacancy is there, that is why in my affidavit, probably that district judge stated that his case is under consideration. As and when it is posted, right?
Madam, let it be after vacation.
In fact, this compensatory appointment is not required to that department or that of some other place also.
It is High Court or what? No,
Family court,
family court is subordinate, but their appointment is always meant by that is they paid by the government, my lord.
Adjourn.
My lord, this is not tenable.
Oh, you will rely on my judgment. Past.
Not yes, my lord, judgment. Again, my lord, a coordinated bench has passed judgment, stating that when a minor becomes major, he cannot claim that. That is,
but our High Court already granted the minor.
My lord,
in some other department also.
My lord,
What I am suggesting is adjourn it.
affidavit in opposition to be taken.
Affidavit in opposition has been filed by the stated to have been filed by the respondent number 3. However, same is not on record. Accordingly, list after vacation.
It says lordship
registry to
4-5
take the slip. Don't say that. Date now.
after vac-
After.
after.
There are two vacation, my. One is my lord.
After
One
we-
is
This compassionate appointment, we are not specifying anything. I have my own reservation. That is the problem. Mr. Mohanto, problem is that everybody is having a compassion for these people, but the law,
No, my lord.
but law and the notification itself has mandated that you have a time to be compassionate for this year, for us. And the Supreme Court says, don't have compassion even if it is pending in this court. What to do? This cannot be a regular mode of appointment.
Obviously,
Because some other person who also needs compassion,
my lord. Yes,
those who are
compassion
qualified, those
meaning
who are
by the
not,
diary,
because demand is huge, supply
Huge.
is very less.
Yes.
So therefore, that is we'll have to balance.
Yes.
Don't go further. We have adjourned it, adjourned. Yes, Mr. Purva.
Pleasure, Lordship. It's going to be on that. As an student advertisement of ideas board, including post of one junior technician TL and two posted reserved for physically disabled mark for reservation mark for disabled category. I am also one of disabled category hearing impairment of hearing. I applied, though it is a online, then thereafter I have a paid interview, not qualified. I issued appointment letter, power of appointment. Thereafter, when I went for joining, this medical officer certificate is required. Here it is, how do they come up? That certificate was issued by the medical authority, the permanent, it is not a temporary disability up to 25, up to a year of 25 plus.
Yes, what is the instruction?
My instruction is that we have filed the affidavit, my lord. My lord, here so far the
You are representing whom?
one to four.
ONGC. No, for the time being, we'll hear you.
Government is
Your case is that you have given a temporary, give me the permanent and take the appointment.
That is there.
Lordship, here, Lordship, the difficulty is that since it pertains to hearing, Lordship, there is a chance of variation. That is why we have given it for 3 years and 5 months. It is valid till 25/10/2025. And after that, Lordship, he will have to re-examine himself before the board. And then, Lordship, if it is found to be more than 40%, then only we can.
No, what is according to him now? He is 40%.
No.
Now he's 55%.
55%.
Up to 25, year of 25.
Still, Lordship, because we give some time, Lordship, because
So
this might vary,
according to
Lordship.
you, after in this kind of disability, you need a reassessment after a specific period.
Yes, Lordship.
You have it. You give him appointment subject to his subsequent.
That is like prayer, my lord.
Subsequently, Lordship, if he fails,
My lord,
if he fails,
If he fails,
he fails, he'll go out. That is opposed, my lord.
no, how can he go out? That is a different issue. How can we determine now? No, there is the as on date.
As on date, Lordship,
If he is a disabled, he is disabled.
Visible, my lord.
Appoint him.
Yes.
as a similar case was before the Honorable my lord, Delhi High Court. And this is the issue, my lord. And Delhi High Court has said no. As per the definition, my lord, of right of person with 2016, my lord, section 2F. Person with disability means a person with long-term physical, mental, intellectual, or sensory impairment. Plus, since in the certificate, particular date is mentioned up to 25/10/2025. So therefore, it has
Where is the procedure that it should be given only temporary?
no.
Lordship, 18 Lordship.
What is the position as on that post is vacant?
Post is vacant as per
Interim is there,
order of reasonable court, my lord. And
This
my
is an
lord,
important issue.
My lord,
We'll have to deliberate it. This is an important issue.
Yes.
What is the
place
procedure?
Huh? Because
Lordship,
some kind of my lord, the permanency must be.
Okay. Prima facie, and there is an arguable case. What is your state?
Lordship, as per the rights of person with disability rules, Lordship, 2017, Lordship. 18 Lordship, issue of certificate of disability. And Lordship, under that 18C Lordship, 1 and 2 Lordship.
What it says?
Lordship, the medical authority shall, after due examination, 1, issue a permanent certificate of disability in cases where there are no chances of variation. But Lordship, here in this case, there is a chance of variation. Lordship,
pertains to
Okay,
hearing.
anything on the chances of variation rule
Lordship,
that it should be a temporary?
shall only issue permanent certificate of disability.
Okay,
Only
that
issue
we understand,
Yes.
but they have issued a temporary.
Yes, Lordship.
Where is the provision of temporary?
He may recover also in this period.
No, we understand. Since they are the competent authority constituted under an act. Now they must have a power to issue a temporary certificate. Where is that?
Lordship, we always issue the temporary certificate at first, Lordship. In all the cases, Lordship.
No.
Yes.
Issuing is one thing and a power is one thing. Where is the power? Or procedure that you will have to issue a
Form
temporary then permanent.
It's under 18 only, Lordship. Form C.
Form C, Form 4 should
Form
be there.
Form 4.
Form 4 relates to which section?
Rule 18, my lord, this is permanent. So for Form C is concerned,
It
my lord,
relates to
this
temporary.
is temporary.
Where is
Temp-
anything mentioned on temporary in the rule?
Temporary.
See, this determination will have a far-reaching consequences.
Yes.
Suppose a person is a disabled or a differently able person. That determination is need to be made by a competent authority under a statute.
Yes.
Okay. So they will have to give either in terms of the act or rules made thereunder. So therefore, they will have to have a power to issue a temporary certificate. Now, next question will be if there is a power to issue a temporary certificate, what will happen to this person in case of employment? What the act says?
Lordship, in that case, Lordship, Rule 17, Lordship.
What it says?
Application for certificate of disability. Any person with specified disability may apply in Form 4 of the certificate of disability and submit the application to a medical authority or any other notified competent authority to issue such a certificate in the district of residence of the applicant as mentioned in the proof of residence in the application.
No, that is the way to apply what to do. That is
Yes.
fine. What we want to
But
know is, suppose where is the power to issue a temporary
Temporary.
medical certificate? This is one. Second, if any power is there and certificate is issued, what will happen to this person? What will be their right? Will their right be limited for an appointment to a post for a specific period, or once appointed? There should not be any confrontation with two rights. A person is selected, appointed, and his appointment be till next things is brought in.
Here, the certificate itself, my lord, Form C under Rule 4. But my lord, he should apply for certificate for
No.
Form 4.
What we want
He
to
has not applied for Form 4.
tell us where is the power to issue, Mr.
So we do not have
17.
because as per our inspection, my lord, your lordship issued the certificate is mentioned about this rules and everything. Thereafter it's been issued where 40% required, I have 50%. In advertisement also that particular column is there.
No, understand. We see it's a larger issue is there.
It is a
Your
definitely-
certificate
yes,
is a temporary certificate.
yeah, that is my lord.
Where is the power to issue temporary certificate and under what circumstances? Tell us that.
My lord, they only because in this regard, my lord, they have taken affidavit, they have stopped affidavit. In that 13/10/2013, it is said affidavit about to be dated, about to be the same day, given for which time. Again, it's coming in November. 2 weeks time.
No, that we understand. We will decide today itself. If
That's
you
why,
show
my lord,
us.
my thesis can be said by only authority. Sir, my view is concerned because as on that there were no it is mentioned in advertisement particularly that it should be permanent. Because here it is saying
No,
50%.
it need not be mentioned. First of all, we should understand, is there any scope for issuing a temporary disability certificate?
My lord.
Number one. No, you are a petitioner. You are having a
Correct.
temporary disability.
Correct, sir.
Second
But-
issue is, if that be so, what will be their status so far related to a selection? Because they are temporary, subject to finalization. What will be your right?
Mission is here. My right is here, my lord.
Okay,
My right
list
is
this
immediate
matter
here, my
after
lord.
vacation.
Yes. On-
As prayed to on the prayer of the learned counsel for the parties, list this matter after vacation. If this matter comes to discourse, these questions will have to answer this question.
Yes,
Will not straight away go there because this will have to show your source of power.
Yes.
And if any power is there, how they are to be treated? What will happen to their appointment once issued?
Honorable Delhi High Court said.
Oh, Delhi, for Delhi will go to later.
This is the latest.
Let us first understand, decide the Guwahati High Court. Delhi will go on later.
Interim period, interim protection, 120.
Interim order pass shall continue till then. Give a date. Last part.
Maybe 9 January will.
No. Huh? 12th January.
Hello.
Matter pertains to regulation service of the petitioner. So process is initiated, but the finality has yet to be done.
Yeah, initiated process for regulation.
Yes, page 33.
From the Dimahasa authority, they have sent a proposal. Ultimately, the government has given us the instruction. This is in fact today. They have said that as per the office memorandum of the finance department of 16th June 2012 cannot be. And in the
See, we cannot direct. Exceptional certain conditions. Who are you? You want to regularize them?
We have set up proposal.
They regularize them. Why you need state government's finance or approval?
Not without knowing the pros and cons, they used to send the proposal so that they are
Therefore, why you need their approval? Do it. It's the not Planet Standing Council for the PWD department. Praise for entry granted 3 weeks time. Oh yes. Nayak for 7. Take your name. M. Burman for. Okay. He's here. SK Medi for respondent.
The meta party according approval of the minutes of the division of the petitioner.
Lordship, first of all, they have not annexed the appointment letters, the Lordship, of the petitioner. And there are, as far as from the petition list, seems that they have been appointed grade 4. So, as
where is the minute?
Lordship, minus. But you will find page
20?
Page 20, your Lordship.
Where is your name?
Lordship in the bottom, seal number 3.
Devaranjan.
No,
Durgeswar Das, your Lordship.
Durgeswar Das. Do you disown this?
Lordship.
Now this is by Superintendent Engineer PhD.
Yes, the Lord.
It was after recommendation that was sent for the approval of the chief.
You say that their appointment, you doubt their appointment.
Yes, the Lordship, because they have not annexed, they are appointed as
Therefore, do you doubt this document?
I doubt this document, Lordship. That's why you're not taking a call on the promotion, Lordship.
No. If you doubt, get a clarification
Yes,
from
Lord.
this authority.
I'll get the clarification.
Can we decide whether they're appointed rightly or not rightly?
Page 26.
According to him, on 10/5/2023, Chairman Selection Committee comes Superintending Engineer with all his members, DPC, health, and a recommendation was made. You say that this is filed that there was no recommendation. Should we record that? That you said that you say yourself doubt it.
Let me get the clarification, Lord.
We'll record it. We'll record it that they themselves doubt it. So they will verify and come back to this court.
Let me get the clarification, Lord.
Don't say.
But this appointment expert.
Oh, that is your internal matter. You have made a recommendation. You say that they are not entitled because their appointments were not there. Reject their case.
Very well.
Or you say that this itself is a fake document. They say as that.
Not.
Or if you want to endeavor as whether they are appointed rightly in a promotional method, do you want that?
Lordship, let me get the clarification on that. The
case of the petitioner is that what is called the just a minute. The division level selection committee for promotion to the post of section assistant has recommended the name of the petitioner under category OBC for promotion to the next higher grade. by its communication dated 10/5/2022 within bracket annexure 2. However, the chief engineer has not taken a final call on the aforesaid recommendation. We'll dispose it of. That is, let them decide, including genuineness, everything.
And pass the speaking order, doctor.
Okay. Uh, the claim of the petitioner is that accordingly, the present writ petition is filed assailing such inaction on the part of the respondent chief engineer.
For a time, case 26 by date of 20.
No, we will not go to all this. Let them decide. Case
26.
We will not go to that. Full stop. Full stop. Though promotion is not a right, but consideration for promotion is a valuable right. That being the position, the respondent employer shall have a bounden duty to consider the recommendation purportedly made by the division level selection committee for promotion to the post of section assistant, wherein amongst others the name of the petitioner also finds place. Full stop. The Learned Standing Council raises certain questions regarding the actual appointment of the petitioner and the validity of such recommendation. Full stop. Recommendation. Full stop. However, this court is not inclined to endeavor into such an issue at this stage, as the matter is pending before the chief engineer for consideration. Once the chief engineer considers and takes a call, that can very well be challenged by the petitioner. But this court, at this stage, when the matter is at the stage of consideration only, should not endeavor, in the considered opinion, should not endeavor into the merit of the claim of the petitioner as well as of the respondents, so far same relates to the promotion. Accordingly, the present writ petition is disposed of, directing the respondent number
Respondent number 3
to take a decision on the recommendation made by the district selection division level selection committee of Guwahati division or what? Guwahati division 1. Guwahati division 1. Within bracket annexure 2. Division 1 dated 10/5/2027 within bracket annexure 2. Within a period of 4 weeks from date of receipt of a certified copy of this order to be submitted by the petitioner before the respondent number 3. Respondent number 6, chief engineer. Respondent number 3. While parting with the record, it is made clear that this court has not opined on merit either on the claim of the petitioner or of the respondent.
Highly obliged.
I'm appearing for the petitioners over here. If this matter pertains to promotion to the post of junior information officer from the junior information in the Directorate of Information, Public Relations and Media Department. Accordingly, Lordship, we have the government has filed an affidavit just last week, Lordship. We received it, so therefore now, Lordship, it may be allowed to file it. I think the private respondents will have to file their affidavit.
Lordship may produce the order dated 6/12/23 passed in the IL.
6/12/23
passed in the IA 3354 of 20. 6/12/2023 passed in the IL.
It's already directed to be.
IA.
Lordship, the IA for impleadment. This is today the main cases before us. I had mentioned it. So because the interim was, Lordship, question of interim was there, so to extend it. And Lordship,
There is already
and also Lordship, an affidavit was filed. So
Since I have come,
I might be taken then, Your Lordship. I already have filed an objection, Your Lordship. Twice they got,
he has filed, Your Lordship.
twice IA has not come today, Your Lordship.
IA is in the list, Lord.
IA is in the list, but it will come, Lordship, it is 6th on January, Your Lordship.
Lordship will
And
take up the
moreover-
main matter today and the IA in the month of January.
Last time, Lordship, IA was taken, the main case was not taken. Can't say that.
Okay, we'll take the IA on that day. Let us vacate the stay order.
Lordship. Say, my lord. Say, my lord, my lord, may
Isn't it?
my lord extend it.
So this has come, we'll vacate today.
Now, Your Lordship, Your Lordship, in the main writ petition, he to challenge the draft gradation list, Your Lordship, in which my name appears, Your Lordship. I mean, necessary part.
My lord, he is an ex-cadre post. My lord, first of all, my lord,
That's in the medical.
IA is for, my lord, the IA is for promotion to the post of junior information officer.
Mm.
If your lordship sees the rules,
Mm.
the rules does not show that the rule is specific, your lordship. An ex-cadre post, he does not have a right. There has to be a right. First of all, lordship, substantive right has to emanate from rules. Any action taken and not supported by rules is void ab initio. When the person, he doesn't have, he's an ex-cadre post, he's not in the feeder cadre. He has no right to be, he has no locus.
He
And
has
my lord,
no right to be in the draft gradation list.
he's not,
Isn't it?
he has no right to be in the main case.
No, not main
And
case. He
necessary
is not
party-
even having any right to be in the draft gradation list. Isn't it? Because he's an ex-cadre. How can he be brought in the main list? Isn't it? When he is an ex-cadre, can his name be in the draft gradation list?
He's not a necessary party.
No, no.
In my submission is that he's not a necessary party in the main, because he's an ex-cadre.
What is the main case?
The main case is regarding, my lord, junior information promotion to the post of junior.
What is the
information-
challenge in the main case?
My lord, the petitioner, I am the petitioner. I am a librarian. If
No,
your
no.
lordship-
What is the challenge?
challenge is that promotion to the post of junior information. I am eligible for promotion. I have acquired all the qualifications.
They are proposing to promote whom?
Promote myself.
No, no. Your grievance is that they are not proposing to promote you.
Yes.
They are
According to rules,
proposing
according
to
to
promote some according to
According to
proposing to
rules.
somebody else.
Yes.
Who are
According
they?
to-
Somebody else is there.
One person has been promoted. Your lordship, that is the
number 7.
response number 7 has been promoted. And I am the petition. I am both of us a librarian. And rule 11.25 of the DIPI rules is specific. Rule 11.25. So I will give a copy.
What is your prayer in the writ petition?
See the order. 19, page 18 and 19.
What is 13/12/2022?
13.12.22 is a gradation list, sir. Impugned gradation list.
So that is under challenge.
Challenge.
Whose name was there?
Lordship, the translators are ex-cadre post. Like
Suppose we set aside this gradation list, so name will go. Whether Mr. Bothago's class name is there in the gradation list.
there, my lord, but my lord, my lord, before, my lord will come in, come to rule 11, lordship. 11 is 11.25. There, my lord, subject to this thing, my lord.
According to you, the person who is man who is being represented by Mr. Bothakur is having no locus.
No locus.
Because listen what I put under. Because he is an ex-cadre.
Yes, sir.
So therefore there is no scope of giving him promotion. Isn't it? So therefore he is not necessary party.
Rules also is not
No,
specific.
but-
Translators are,
But problem is this, you have challenged the gradation list on the same ground that this man who is not eligible is in the gradation list.
and your lordship, one more
This
thing.
is a simple issue.
And then one more thing, your lordship.
No,
That
we'll
main
go
case-
to
that
the
main
one
case-
more first. Let us
Regarding-
cross the first hurdle. A gradation list is under challenge. A person's name is yet there. Suppose we set aside this gradation list. Will he not be affected? Or we can say, no, he is not affected because he has no right even having to go there. So let us decide in absence of him.
Lordship, but in substantive right has to emanate from rules and any action taken.
Oh, understand, that is on merit.
Merit.
According to you, that gradation list should go and promotion made to him should go, because these people are not at all entitled even enter into the gradations list, not to say to the further promotion. Rule will not permit it. So we'll set aside it. No problem on that. We'll set aside. But can we set aside without hearing them? If you say yes, we are saying yes, subject to at your risk. Say.
But I would like to say one thing, Lordship, just one judgment I want to show regarding twin test. Lordship, para can be allowed. I don't concept of necessary party and thing party. Paragraph 20, Lordship. For being it can just be seen that what has been held by this court is that for being a necessary party, the twin test has to be satisfied. The first one is that there must be a right to some relief against such party in respect of the controversies involved in the proceeding.
Okay.
And here, my lord, he has no this thing because
okay, very good. You have given us this judgment. Thank you. Hard. IA. Take down in IA. You have filed impleadment, Mr. Bhattakar? Hard. Mr. Bhattakar, learned counsel for the applicant. Also hard for the writ petitioner, opposite party. The present application is filed. Though this matter was fixed, though this IA was fixed in the month of January 2024 by this court under its order dated 6/12/2023. However, the connected petition has been listed today. Today. As the matter is listed today, the IA is taken up for consideration. The present application, the case of the applicant is that, amongst other, the writ petitioner has challenged a gradation list dated 13/12/2022, amongst other, prayed for a writ to recall, rescind, cancel a gradation list dated 13/12/2022. It is an admitted position that the name of the present applicant is included in the aforesaid gradation list. Accordingly, Mr. Bhattakar submits that in the event the gradation list is set aside by this court, gradation list is or this writ petition is allowed by this court. In the event this writ petition is allowed by this court, a valuable right of the petitioner, replicant, shall be violated without caring. Mr. Fukan, on the other hand, has vehemently opposed such impleadment on the ground that the present applicant, in terms of the extent rule, is not having any right to the next higher promotion, and therefore he is not a necessary party. And in support of such contention, Mr. Fukan, not necessary party, and therefore the twin test as laid down by the Honorable Apex Court in the case of Morrison Swenso versus Swenso, reported in 2022 SCC Online SC 13C0, is not fulfilled. Accordingly, according to Mr. Fukan, the present applicant shall be present applications is required to be dismissed. Required to be dismissed. We have given anxious consequence. The determination made by the Honorable Apex Court and relied on by Mr. Fukan rather helped the case of the applicants. The Honorable Apex Court in no unambiguous term held that two tests, that is, the right to some relief against such party in respect of the controversies involved in the proceeding is required to be satisfied. And secondly, that no effective decree can be passed in absence of such a party is to be satisfied. First of all, in the case in hand, the gradation list impugned in the writ petition figures the name of the applicant. Figures the name for the applicant. Therefore, prima facie, his employer has made a has included his case for consideration of promotion to the next higher grade. That being the position, he will that being the position, he shall definitely have a right in the present right to contest the present proceeding, for the reason that in the event the writ petition is allowed, the already accrued right to him in virtue of the gradation list in question shall be he shall be deprived of his already accrued right in terms of the gradation list. Inasmuch as this court at this stage cannot reject an impleadment petition entering into the merit of the case, that the applicant is having no right to get promotion in terms of the rule, therefore he is not a necessary party. Such course of action is not permissible. Secondly, the second condition, that no effective decree can be passed in absence of such party, is also applicable in this case, for the same reason that in the event an order is passed, same will violate the right of the applicant without he being heard. In that view of the method, the objection raised by Mr. Fukan stands rejected and the present application stands allowed. Accordingly, registry to correct the cost title and cost title and do the needful in this regard. First off, in the main case, you write it down in view of the order passed today in ISO and so, registry to correct the cost title. First off, the newly implemented respondent number 11 may in the meantime file affidavit. Please this matter after 2 weeks. The interim order passed earlier will continue.
Deeply applied.
Lordship,
Yes.
in this item number 40, Lordship, a connected writ petition is fixed on Lordship 21st of December, your Lord.
What is the issue here?
Lordship, I have been terminated. I have been terminated from service after serving the law.
Okay.
My contract.
The learned counsel for the petitioner submits that similar issues similar to the present issues raised in the present petition and similar writ petition are pending for disposal
21st of
on 21st of
December
2023. It not necessary. List this matter along
with WPC 4182 of 2003.
on 21
on 21/12/2000.
That will do because that is only
Yes, Lordship, that's
already fixed it.
41
40
also, Lordship, a different repetition. In this case, Lordship, I have been served without
Okay, then 41
list along with 6627 of 2003
on
on 21st.
Applied.
Much of it.
That pertains to termination of the petitioner on the grounds of medical grounds that he sustained injuries during his training.
Mm.
He was a CRPF.
where is your Mehdi? Is it possible?
Impugned order method, page number 36. It was subsequently amended to amend the rule method.
On legs? After vacation.
They have
Okay, we fix it at 23. We submitted that the schematic. Learned found CGC is having some difficulty today. Accordingly, method set. List this method on 24th of January 2020. No, not possible. It would have been possible.